ಅಷ್ಟು ಮಾಡ್ತಾರ ಯಾರು ಯೂನಿವರ್ಸಿಟಿ ಸಂಗೀತ DBS make available.
Serial number 7 ಸ್ವಲ್ಪ ಫೈಲ್ ನೋಡಬೇಕು. ಓಪನ್ ಕೋರ್ಟ್ ಇಲ್ಲಿ ನೆಟ್ಟಲ್ಲೂ ಫಿಸಿಕಲ್ ಕಾಪಿ ತೋರಿಸ್ತಾ ಇದೆ ಅದಕ್ಕೆ ಇಲ್ಲ ಟೈಮ್ ತಗೊಂತೀನಿ ಅಷ್ಟೇ.
ಎಲ್ಲ ಚೇಂಜ್ ಆಗಿದೆಯಲ್ಲ ಮೇಡಮ್? Maybe 3. That is specially for case things. Motion करसी. ಇಲ್ಲಿದಾರ ಸಿಂಗಲ್ ಬೆಂಚ್ ಏನದು
Posting the commercial appeal, we have filed an IA for return of original document. It's an urgency.
Which is this matter?
Hello.
Blood. Commercial.
From the other side.
We'll do.
24 tens.
No. Commercial appeal of the year 22, my lord. I am for the appellant, my lord. I had filed I-8 to recall, permit me to file WS, my lord. Because during the period of COVID, my lord, it's a partnership dispute, my lord, between the two partners, my lord. I was partner who was experienced. Subject matter challenge, my lord. I had filed an IA before the trial court, my lord. To permit me to file a written statement, my lord. That was rejected, which I have challenged it in appeal.
For posting for 78 of the commercial. Commercial appeal 78 of the.
So appellant has filed the commercial appeal. So the interim stay has been granted on the condition of deposit of 1 crore. I felt I had to release that 1 crore of amount to your lordship. I will inform your lordship.
Sir, I am the appellant, 14%. This is a commercial appeal. The trial court has passed the order and judgment as allowed in part. So we have filed a commercial appeal for partial modification of the trial court order. Now it is versus a KSFC, financial institution. That is a commercial in loan. Then now it is already reached the final hearing. Court wanted some clarifications. I have secured certain documents from the KSFC and I have filed it now. So for the final hearing, my lord.
Final hearing here,
Yes, my lord.
just take it. Is it a fresh matter? No. It's a
Yes, yes.
21 matter.
Yes, yes.
Just have it in November, man. Just have it.
Court has also,
What is KSFC?
Karnataka State Financial Corporation. My lord, court has asked me to give a synopsis and as well as some citations.
Filed it,
Yes, I'll produce it at the time of hearing.
give,
Not at the time.
Sir,
You produce all those things.
citation on the other things I'll produce before the,
you file it,
oh, sir, my lord.
give it to the other side also,
Okay,
and inform the other side about the listing, the
Okay.
date also.
okay.
611.
Just 1 minute.
Say
6th of November,
6th, I have another case.
which is the date convenient? Tell
7th,
us.
7th.
My notes.
Just 1 minute, ma'am. Ask them to inform the other side. Ask them to inform the other side. Yes, ma'am.
This is a fresh matter. It's an income tax appeal.
Yes. You inform the other side also about the date,
Okay,
okay?
Okay.
And take an acknowledgement also.
okay, my lord.
Then give it to the court officer.
Okay, my lord.
Just take this back, just inform the council, take a acknowledgement and then give it here.
Okay, I will take this.
My lord, this is a fresh matter. It's an income tax appeal. We have filed an appeal against the order of the ITAT remanding a matter to the assessing office. It may kindly be taken up on
Just take it.
on the coming Monday, my lord.
Think what is the convenient to you? Just take it, what is convenient.
Yes.
Next Monday. Oh, yeah, that's it.
28 and
We'll have it on Monday, next Monday.
great.
My notes, I'm moving a commercial appeal, a 2022 commercial appeal, my notes. It's an appeal from a 34 order of the commercial court. A stay has not technically been granted, my notes. I'm appearing for the respondent. However, the matter has not been heard since the year 2023. So my execution petition is being stalled, my notes. If the matter may be heard on the 23rd
Go
of,
ahead with the execution. There is no stay.
my notes, they're seeking time, the JDR is seeking time stating that the appeal is pending, which is why the court is also hesitant. on
Just
this.
give that. When is the execution now listed?
Manots, it's coming in the next month, Manots. I'll clarify the date if it could be had on the 23rd, Manots.
Yeah, ma'am, we'll just have it this. Just get it listed, ma'am. Any day convenient, see in the first week November, so second week.
Madam, 7-11.
Much appreciated.
My lords,
Yes,
my lords, the IA has been filed for the deposit of the, for the deposit, withdrawal of the deposit made by the appellants to the creditors. I am the liquidator in this matter.
you are the,
Liquidator.
just give it in first or second November. This is our only first. This is our only. We will see it. We'll have it, but the liquidator appointed,
Yes, ma'am.
you are representing the liquidator.
Liquidator.
You serve the other side also.
Will serve. Date, ma'am.
Yes, call the list, ma'am.
For adjournments, page number 425. Page number 5, 26 to 30. Page number 6, 31 to 35.
Your Lordship, serial number 33, Your Lordship. 33. In this case, Your Lordship, Soil Dutt advocate from Delhi is addressing the arguments, Your Lordship. Earlier, he also addressed arguments, Your Lordship. May I request for 411. Beg your Lord.
Just see, you file your submissions, or everyone has filed the submissions here.
I have also filed, my lord. Both the parties have filed.
Parties have filed it. This one, okay, just say this, request for adjournment is made on behalf of the senior counsel,
Yes, Your Lordship. Soil Dutt, Your Lordship.
senior counsel appearing for the appellants in 33, 33.1, 33.2, and respondent in 33.3 and 33.4.
Yes, Your Lordship.
Okay. We have been informed that the written submissions have been filed by the parties. Now you are the common counsels in all these appeals.
Yes, yes.
List on, just give convenient date,
Your Lordship,
Monday.
4th, Your Lordship.
Ask him to appear through virtual mode.
No, he wants to come directly, Your Lordship. That's what he told. Because he.
Make any difference?
Sir.
Okay. We'll give a, see, fourth, we will see it.
Much of.
Just one, see
Yes,
what
Your
is
Lordship.
convenient. Not fourth, ma'am. We'll have it on 11th.
Much.
Okay.
My lord, serial number 31, if I may mention, my lords.
Serial number.
Serial number 31.
Yes, which number?
Serial number 31, my lords.
31.
31, no, the instruction of the
Yes.
client is to engage senior counsel. Lordship may kindly have it on any other date, my lords, next week preferably. 28th.
You appear for the appellant.
I applied for the respondent in this matter, my lords.
Who appears for the appellant?
Raviraj, Shri
You
Raviraj.
appear. Wants an adjournment. The request for adjournment is made on behalf of the council, on behalf of the respondents, list of counsel for the parties to file their written submissions along with the judgments they want to rely upon within, say, 3 weeks.
Obliged.
My lord, serial number 34.
5511.
My lord, serial number 34. My lord, in this matter, senior counsel A. Shankar sir has been appointed.
Pardon?
In this matter, senior counsel A. Shankar sir has been engaged. Humbly request for
For whom? For whom?
appellant, my lord.
Hmm.
due to some personal inconvenience, he's not able to appear today, my lord.
Is it a date fixed matter?
No, sir. No, sir.
At the request of counsel for the appellant, re-notify.
Your Lordship, serial number 35 and 36, Supreme Court remand matter, transfer pricing issues, my lord.
These are transfer pricing.
Yes, my lord. 35 and 36.
Who appear for the other side?
35 on Sharath is appearing, my lord. He is
Your Lordship,
online,
I am
my lord.
appearing for the respondent, Your Lordship.
My lords, in 36, may I be permitted to take notice?
35. Now tell us one thing. These are the actual remanded matters?
Yes, my lord.
They
Yes,
are not connected with, they are both transfer pricing, also remanded.
Remanded.
What do you want? Is it an admitted matter?
Your Lordship, yes, my lord, it is posted for final hearing. It may be deferred for 2-3 weeks, my lord, until the coordinate bench disposes of the matter.
Now, shall we give a date or not give a date?
Your Lordship, date is not required, my lord. We'll move the matter once the case is disposed of.
Just say this, counsel for the party states that. But if this, okay, this is a remanded matter, it's not being heard.
Not being heard.
Only that matter is being heard.
Yes, my lord.
That this is a remand matter by the Supreme Court as the coordinate bench of this court
Yes, my lord.
is hearing the issue of transfer pricing. This appeal be deferred to await the outcome.
Yes, my lord.
Good stuff. Accordingly, list on, what do you say that?
Your Lordship, after
What do you say? Due course,
due course.
due course. But only thing within understanding, once that is filed, you must.
Please,
file
ma'am,
an
I will
affidavit.
inform you. I will move the court, ma'am.
Smooth the court.
Yes.
Yes, ma'am, 36. 36,
36, I will file my wakalat for the respondent.
so and so appears for the respondent state she shall file wakalat on behalf of the respondent. This matter is also remand matter by the Supreme Court, as one of the remand matter is being heard by a coordinate bench of this court. The counsel for the party submits that the matter be listed in due course to await the
Please.
outcome of the appeal being heard by the division bench, by the coordinate bench. At their request, re-notify, list in due course, they shall file their written submissions along with the judgment they want to rely upon. Say same also in 35.
Your lordship, serial number 43, your lordship.
Just 1 minute.
Please, apologies.
Anyone 37, 38, 39?
38, my lord.
Yes.
My lord, I'm appearing for respondent in this matter, my lord. Senior counsel is not keeping well, so I humbly request to adjourn after 3
Is it a
weeks.
date fixed, ma'am?
No, sir.
No. You appear for whom?
Respondent, my lord.
Who appears for the appellant? Mr. Sanmati, you appear?
No, sir.
Mr.
Raviraj.
Yuvraj, you appear?
Me.
At the request of the counsel for the appellant, re-notify on.
212.
Just say that arguments, submissions. Just say so. Ma'am, say about the submissions, submissions along with the judgments. Just say that in this also.
Page number 8.
Much of.
Lordship, serial number 30, your lordship. Courtec Ventures Private Limited.
Hmm?
Courtec Ventures Private Limited. The appellants have preferred appeal before this.
Which now, which meter?
Serial number 30, your lordship, 30.
Just 1 minute. We'll just come back to that. Ma'am, which is the page?
Page number 8, 42 to 45 in adjournments.
43, your lordship.
Ah,
Senior is not keeping well, your lordship.
Lord, I am for the respondent, my lord, 43.
pardon?
This all in serial number 43, my lord.
Yes.
I am for the respondent. This honorable court has directed the department to produce the original records, my lord. A date may be fixed so that I can get the records, sir. 43.
The 43 request for adjournment is made on behalf of
The appellant.
on behalf of the counsel for the appellant, which request is not opposed, adjourned to the counsel for the,
A date may be fixed.
yeah, we'll give a date. Respondent states that the record as directed shall be produced on the next date of hearing. We'll give a date.
9/12. Grateful.
44, my lords. The appellant here is a fully owned Karnataka state government corporation. The issue seems to be technical.
We'll hear it.
Very well, because I had sought instructions on whether there can be an interdepartmental resolution.
So if you want to work out.
That's the submission.
But can't have two parallel, na? Either you withdraw, then work it out.
Well, I'm for the state. You
are for the appellant, na?
No, my lords, I'm for the respondent.
Who is for the appellant?
I had informed Mr. Ashok GV, who appears.
Let him come.
Very well, because I'd spoken to the department this morning and then said, asked him whether he wants to explore that. He said he'd take instructions.
No, let him come. Let's see that.
Your lordships.
Yes.
In serial number 45, lordships. For the respondent, your lordship, 2 weeks time may be granted for compilation, your lordships.
For?
Compilation, your lordships, to file paper book.
Who appears for the respondents?
Yes, your lordships.
You appear for whom?
Respondents, your lordships, GMR Hyderabad International
Is
Airport.
for the appellant.
Philip.
The counsel for the respondent seeks adjournment to file compilation of what?
Paper book, your lordships.
Of the lower court record.
Yes, your lordships.
Tribunal. File a compilation of the, to file on record, to file the record of the appeal before the ITAT. Let the same be filed by giving a copy to the learner counsel for the appellant. Adjourn to.
I think probably it will be case laws, my lord. The lower court records will be part of the appeal, will not as an.
I have not seen it. It's not there. It's just very thin volume. Still recollect. It appears there is not there.
1612.
Next, let's call from one.
Grateful, your lordships.
But serial number 40, my lord.
40?
Serial number 40. I'm for the respondent. The tax effect in the appeal is below the monetary limit, my lord.
Huh?
The tax effect in the appeal is below the revised monetary limits, my lord.
So what do you want?
My lord, the appeal has to be dismissed, my lord.
Who is the?
I am for the appellant, not the tax effect.
Mohan Maya is here only.
How much is the
For
tax?
court number 2.
2 crores, my lord.
So
Now-
anything above 2 crores, you file appeals.
Yes, my lord.
Anything
Now, as
less
per
than-
the latest circular, it is 2 crores, my lord, but there are some exceptions set out in instruction number 5 of 24. But this case does not fall under exception, my lord. But your lordship, this honorable court, my lord, has passed orders in more than 300, 400 cases, my lord. Similar order may kindly be passed in this case also, my lord, giving liberty to seek for revival in case the case falls under exception. Similar orders are already passed, my lord. The same order.
We have heard Mr. Sanmati for the appellant's revenue and pardon? So and so for the respondents. SSE. The revenue is in appeal against order dated this is 31st January 19. No. 11/1/2019. Are we right?
Yes, my lord. Impute order is dated.
Passed by the Income Tax Appellate Tribunal A, Bangalore. In 2 appeals, 2 cross appeals filed by the parties herein being so and so. Then take it from page. Should be page 5, I suppose. Annexure A. Okay.
Page number.
Good stop. The appellant revenue has raised the following substantial questions of law. Just say that the appeal pertains to the assessment year
910.
2009-10. Full stop. The revenue has raised the following substantial questions of law. This you will find at page 4. Full stop. Which has been admitted. Okay, forget it. Just say this, we'll just cut it back. The appeal has been admitted on 16/12/2020. Full stop. Mr. Sanmatil and a counsel appearing for the appellant would state that though
Your
the
Lordship, I
tax,
kindly mention that he has submitted,
Very
respondent counsel.
the respondent states that though the appeal has been admitted, comma, the net tax effect is less than 2 crores. Is it your case? It doesn't fall under the exceptions? It is,
Lordship, the liberty may be reserved if in case.
it is also his submission that the appeal does not fall in the exceptions carved out
Yes, my lord.
in terms of the instructions issued by the revenue.
Yes, my lord.
And as such, this appeal need to be dismissed.
Yes, my lord.
Full stop. Mr. Sanmati, though agreeing with the submission that the tax effect is less than 2 crores,
Yes, my lord.
comma, he prays that the liberty be kept, the liberty to revive the appeal,
Seek for revival.
seek the revival of the appeal if the issue which arises for consideration falls within the exceptions carved out
Yes, my lord.
in the instructions issued by the revenue. Full stop. In view of the submission made by the counsel for the parties, including of Mr. Sanmati, the appeal is disposed of with liberty as prayed for by the learned counsel for the revenue. Full stop. However, the question of law,
Yes, my
the questions of law are kept open to be adjudicated in an appropriate proceedings.
Yes, my lord.
That would be fine?
Yes, my lord.
Okay, thank you.
Please, my lord.
Lordship, serial number 30.
Pardon?
Serial number 30. 30. Seeking a short adjournment of 2 weeks.
Who appears for them? You appear. The adjournment is sought by the counsel for the appellant, which is not opposed, re-notify on counsel for the parties to file their written submissions if not already filed. Along with the judgment they want to rely upon.
Great.
2511. Serial number 1. Serial number 1, Shri Prasanna Kumar.
You are for the appellant.
Appellants, my lords, we have filed our memo of retirement, my lords.
Pardon?
My lords, we have filed our memo of retirement. The same may kindly be taken on record, my lords.
Then who would appear for them?
My lords, my lords, the agency has to direct the other councils, the list of
No,
councils.
then you must take instructions now. Who would appear?
My lords, we do not have instructions. They have asked us to retire, but they have not yet instructed on who would.
See, it should be a representative must be here or the council must be here. We will not otherwise allow you, at least till such time. Okay,
Yes,
just take instructions. If anyone is there, we can record it so that henceforth he can appear also.
very well.
Because there are other councils also who appear.
Yes, my lords.
Just say that the request of the council for at the request of Mr. Prasanna Kumar,
My lords, I am his junior, my lords. I am not.
at the request of so-and-so who appears for Mr. Prasanna Kumar.
Yes.
Re-notify on. Suffice to state that a memo for retirement has been filed by Mr. Prasanna Kumar. Just take instruction, let him be here.
Yes, my lords.
2611. Serial number 2, Shri Dilip.
Let fresh
No,
notice be issued to the respondent,
Liberty may not hand summons also may be.
including, what do you call?
Hand
And
summons.
summons. And summons, returnable on. And don't clog, okay? Don't clog. Monday. Huh? Oh. See, his name is Dilip. Mr. Ravidas, the difficulty is, the report says the addressee left. Either you have to furnish the fresh address. Okay,
Please.
just cut that. The report of the registry suggests addressee left at the in Kadana on the appellant furnishing the fresh address of the respondent, comma, notice shall be issued, returnable on.
1612. Serial number 3, Shri Sanmati.
Same. Yes,
Your Lordship,
there was an additional affidavit to be filed, Mr. Sanmati.
Your Lordship,
This is in support of that application.
yes, ma'am. I pray for 2 weeks' time, Your Lord.
Mr. Sanmati seeks further time to file additional affidavit in support of the IA being one of 23. This is an application seeking condonation.
Condonation of delay, my lord.
So you must file it. Let the same be filed within 6 weeks, list on.
9-12. Serial number 4, Sanmati.
In this case also, my lord. In this case as well, my lord, I may be permitted to file additional affidavit, my lord.
Serial number
This also. They were to file objections, I suppose.
serial number 4. sir.
Huh? Or the other side need to. That's right.
Sir, 4.
Where are the orders? You just give us the file.
Sir, 4, we have to file objections.
Your Lordship, they have to file objections,
Just give us the file.
non-filing.
Just call Jagdish, ma'am.
Better effort, not filing.
Ma'am,
Your
you
Lordship,
appear-
I will file better affidavit in this case also, my lord.
but you were to file objections.
My lords, may I just point out, my lords? My lords, I was to file my objection. I've kept my objections ready, my lords, but the affidavit filed by the department does not really set out any
Will say so. How are you?
no, my lords, in the
You
past.
will say so, take advantage without
Yes, my
written particular. Okay, very well. You want to file? We don't mind. You want to file?
I will file, my lord.
Sure, okay. Though on the last date of hearing, the counsel for the respondent was granted time to file objections to IA 1 of 24, Mr. Sanmati appearing for the appellant's revenue states that he intends to file an additional affidavit in support of the application for seeking condonation
Yes,
of
ma'am.
delay. That's right?
Yes, my lord.
We file within 6 weeks, list on.
9-12.
Full stop. On within 6 weeks, full stop, on filing of the said affidavit, the objection shall be filed within 2 weeks thereafter.
Please. my lord.
Serial number 5, to Dilip.
Mr. Yuvraj, I think this is also, ma'am, this is addressee left.
Serial number 5, sir, left.
On the report of the registry suggests, the report of the registry on service suggests that the addressee left. That left, say that left, quote. On the appellant, for counsel for the appellant furnishing the fresh address of the respondent, notice shall be issued, returnable on. Fresh notice shall be issued, returnable on.
16-12. Serial number 6, to Dilip. It's also left.
Same order.
Seven, to Sanmati.
I pray for 2 weeks, time to file better affidavit. my lord.
Even objection is to be filed after receiving the better affidavit.
Nine, 12. Serial number,
Serial number 9, my lord, there is delay of.
sorry, 8, sorry, 8.
8, apply for a week time to furnish the process fee, my lord.
No such persons. No such. No such person.
Within a week, I will furnish fresh address.
See on the service or this, no such person would be this. This.
16, 12. Serial number 9.
Serial number 9, I may be permitted to accept notice on behalf of the respondent, my lord. I may be permitted to accept notice on behalf of the respondent, my lord.
So I suppose I will not, the delay is only 106 days, my lord. I will press for the affidavit which has already been filed, my lord.
My lord, I seek 2 weeks' time because it's a foreign company.
Yes. Questions to be
I'll share this copy, my lord.
16, 12. Serial number 10. Jeevan Niralgi.
Lord, complied with the office objections, my lord. The cost also has been paid. I'll file that acknowledgement, my lord, today in the office. That is the objection. Yes, I complied with my lords. I filed necessary applications. My lord, it has to be posted for, my lord, for IFR, my lord, condonation of delay. Notice has to be. Matter has to post for admission, my lord, after this. Not at been discussed. If that's paid today, today it is. Yes. My lord, the issue is this, my lord, this arises under GST. Now, my lord, Lordship mechanism, my lord, 2017, this GST came into force. Prior to, my lord, coming into force of the GST, there were several indirect tax enactments, my lord, which were in vogue. My lord, central used to impose central excise duty and the, my lord, the service tax. Yes.
2511. Serial number 11. 11.
11 is also, Jeevan sir.
Sir,
11
11.
is also.
So 11 is on the same, my lords. Same issue, different. Yes. Yes, that is also paid. That is also paid. That is paid, my lords. That's also in both the cases. Please.
2511. Serial number 12, Sri Satyanarayana. 12. 13.
My lord, there is a delay of 845 days delay, my lord. The reason for the delay is, my lord, earlier we had filed the appeal.
Yes,
My lord, I appeal for the bank, R2.
IP for R1.
My lord, I have prepared my objections for the condonation of delay as well as I could not serve the copy on them.
Yes, ma'am.
I think from a common order.
Yes, my lord. My lord, we had earlier preferred an appeal. It was by our mistake, it was wrongly classified as MFA.
Then, my lord, we withdrew within limitation, my lord. Then I withdrew the, yes, yes, my lord.
And your lordship, 44th is a similar matter.
42nd, my lord.
At that time, my lord, if your lordship takes us.
42, my lord.
42.
42, my lord, 42.
Lordship.
My lord, may I make one submission, my lord? I have instruction that, my lord, the offense under the PMLA is set down tomorrow for the hearing on final arguments, my lord. If it end in acquittal, my lord, these proceedings would become infructuous. I request for a 3 weeks adjournment, my lord. By that time, if the, yes.
That the IAs have been filed. These appeals seeking conversion of 345 days.
Yes, my lord.
Very nice form.
Case that pictures to the IAs seeking confirmation of below shall be filed under the request of the court. The prosecution is required to file a response to the same in 3 weeks.
Yes. If it ends in acquittal, my lord, this particular proceedings become. If that particular original proceedings end in acquittal, my lord, yes, yes. My lord, 6 weeks, my lord.
Sir, 12 or 12?
Much.
Including 42, my lord.
42.
Yes, my lord, my mortgage properties are stuck, my lord, and 42 bars them from only 60 days, and another 60 days is court can, only 120 days can be.
The appellate tribunal observes that, my lord, the bank is the victim and already they are in possession. But if the proceeds, yes, they are in. Yes,
OA, surface, all I have initiated. But my lord, I'm stuck because of the attachment order. I only. Yes, my lord. Then that's not proceeds of crime. What has happened is subsequent to dispersal of the amount, that has been misused, and we ourselves went and registered complaint.
My lord, technically, if it is not available with the criminal court, my lord, the criminal court, sorry, the proceedings which is pending before the PMLA court, the PMLA court cannot proceed with the matter. For that reason, technically, it should be with the court, my lord. Definitely, we will not usurp the property or take over the control over the property. Yes, yes, much.
42 also.
42.
42. Serial number 16. 16, Sanmati.
My lords, in 16, my lords, for the respondent, Tanmay Rajkumar's name is reflected, but I am given to understand that some other counsel will be appearing, and we are instructed not to appear in this matter, my lords. Not to appear in this matter. We are instructed not to appear in this matter, my lords. Good. Therefore, my lords, direct Tanmay Rajkumar's name be deleted from the list. Yes, my lords. Tanmay Rajkumar, my lords. My lords, I'm told they have instructed another counsel to appear, and they have told me not to appear today.
Your lordship, it may be adjourned for 2 weeks, my lord. Let the other counsel come and record, my lord.
So say that she shall not be. As the respondent has engaged in counsel. Let's inform the counsel to appear.
Yes, grateful.
11. Serial number 17, Sanmati. 17.
Your lordship, there is delay of 286 days, my lord.
My lords, the delay is not sufficiently explained in the affidavit, my lords. My lords, the affidavit is at page number 75.
Yes. Broadly explain, not way to way.
My lords, this is the explanation that is largely given in all the matters also, my lords. There is nothing specific with respect to this matter, and this is a very generic affidavit, my lords. This is a very generic affidavit. This doesn't specifically explain, this doesn't sufficiently explain the delay.
Your Lordship, this is the general process that we have to follow, my lord. In all the cases, this will be the procedure, my lord. Only thing is, I have not mentioned the date from which date, only that's it, like, dates,
It's, so what we say, can be now subject to pass.
My lords, I will just pass on the decisions of the Honorable Supreme Court on this, but I leave it to my lords.
Both sides. If there are 10 here also.
Very well, my lords. Anyway.
All those things.
delay is less than 1 year, my lord.
Yes, this is something. Currently so delayed that it should not be entertained, otherwise that gives a liberty, everywhere, even 10.
I bought out.
Something on the borderline.
Very well.
Even applications. States that without giving day-to-day, it's resulted in filing of the appeal after 26 days. Having looked at the contents of the affidavit from shall we impose costs?
No, no, if it is more than 1 year, your lordship can proceed. If it is less than 1 year, my lord, use some, it since it's revenue supplement. Your lordship,
Nine, 12,
job list.
serial number 18, should delete.
342 days delay. 342 days delay.
My lord, we want to file objection, my lord. I humbly request for 2 weeks. No, we have taken. Humbly request for 2 weeks, my lord.
Needs to file objections to idea number.
1 of 20.
1 of 20.
We'll also file better affidavit.
File it so that they can respond.
We'll file and give a copy. Please.
Affidavit, support of the applications in the provision of 340 days, that the same to file within 6 weeks.
Sixteen, 12. Serial number 19. 19.
Serial number 19. I may be permitted to accept notice on behalf of the respondent, my lord.
Ankur PD. Ankur. 612. ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ.
Please.
Not yet admitted. Should but page number 17. Yes, page number 17, 1, 2, and 1, 3, and 4 are all sufficient. 2, I don't think it's not required. 1, 2, 3, 4, all the questions, all the questions. 4 questions also.
Six one, 2025. Serial number 20.
Well, Lordship, 20, I want to file better affidavit, Lord. I pray for 2 weeks' time, Lord.
My lords, in 20, may I be permitted to take notice? May I be permitted to take notice on behalf of the respondent in serial 20, my lords?
Tanmay Rajkumar.
2 weeks.
Yes, my lords.
We shall file with other.
212. Serial number 21.
21, I may be permitted to take out notice, Lord.
My lords, 21, may I be permitted to take notice? 21 also, may I be permitted to take notice? Very well, my lords. My lords, could this be kept at this stage? I'm told that the tax effect and this appeal may be less than the prescribed limits, my lords. Very well.
Sure. Your Lordship, the case falls under exception clause, instruction 5 of 24, my Lord, double taxation avoidance agreements, if it is involved, provisions relating to DTA, then the case falls under exception.
I will examine it.
212. Serial number 22.
That's 22, may I be permitted to take notice? In item 22, may I be permitted to take notice?
Your Lordship, I may be permitted to file better affidavit in this case. Yes, Lord.
Nine 12. 23.
Yes, my lords. Very well.
What will be
May I just make one submission, item 23, my lords? Item 23, I have examined the tribunal's order, and my submission to my lords is this appeal does not require admission. According to me, it will. My lords, anytime in December, my lords, 9th December is what my lords have fixed for item number 22. My lords, the issues are the SSCs are different, but the issue is the same, whether consideration for sale of software is taxable as royalty. Unless it is decided by the Honorable Supreme Court, holding that it is not in the nature of royalty. Therefore, my submission is this appeal may not require. Yes, my lords. ITAT has referred to the decision of the Honorable Supreme Court. Relying on the decision of the Supreme Court, this appeal was allowed.
Lordship, review petition is pending, my lord, as far as that case is concerned before the Supreme Court, my lord.
My lords, even on review, my lords, there are some review petitions which are already dismissed by the Honorable Supreme Court.
As far as this particular case, engineering analysis is concerned, review is pending. In Supreme Court case, my lord. Yes, my lord, very case, my lord. Your lordship, our submission is that in each case, my lord, the agreements entered into between the resident company and non-resident company has to be analyzed. Whether the parameters set out in engineering analysis, my lord, day is not fixed, my lord. Date is not fixed.
My lords, very well, my lords. I'll produce the dismissal orders in the review, other review petitions also, my lords. Yes, my lords.
Yes, my lord.
Yes.
Please.
24. 24.
Your lordship, 24 my lord, delay of 10 days, my lord.
I have been this. Yes, my lords.
Let's see that this issue not covered.
Your lordship, similar issues, your lordship has admitted in ITA 454 of 23, my lord, on 15/10/24, my lord, regarding to advertising and marketing promotional expenses, my lord. (454 of 23, my lord), admitted on 15/10/24. And no, my lord. Yes, my lord. Your lordship, the matter may be admitted, my lord. Only in usual court let the matter come, my lord. No, date is not required, my lord.
Listed along with ITA so it's.
Please, my lord. Yes, my lord. Your lordship, admission, let it be admitted, my lord. Yes, my lord. Please, must oblige me.
25. Serial number 25.
Your lordship, this is Supreme Court remanded matter, my lord, relating transfer pricing case, my lord.
Appear on behalf of Shrikant Patil.
Transfer pricing. Item number, it is mentioned in the cause list as well, my lord. Supreme Court remanded matter, my lord. Yes, my lord. Same, my lord.
Said the field.
Please do. Much obliged.
26.
The respondent, my lord, I request for 3 weeks' time to file our objections. Serial number 26. Objection for the stay of. You have to file a detailed objections, so I request for 3 weeks' time to file the objections. Three weeks' time.
3 weeks. Objections to the appeal. And then that we file the release, this,
10, 12,
Obliged.
27. Shri Raviraj.
27 appear for the respondent. My lords. In the last occasion, my lords, the bench had directed us to prepare a short note. The issue, in fact, is again royalty pertaining to that. The CIT appeals had relied on this honorable court's order on Samsung, which had held that payments made to a non-resident for purchase of computer software would amount to royalty. So relying on this honorable court's order, the CIT dismissed my appeal. I then carried the matter and appeal to the honorable tribunal. The tribunal, my lord, in the meantime, the Supreme Court had heard the appeal arising from Samsung. And in the case of engineering analysis, categorically reversed this honorable court's order and upheld the Delhi High Court and other high court's orders, which had held that this payment is not royalty. So before the tribunal, I said that the CIT had relied on Samsung. Samsung has now been reversed by the Supreme Court. The tribunal not only placed reliance on engineering analysis to allow my appeal, independently also it examined the nature of the payments made and held that these payments are not tantamount to royalty. Therefore, I was not required to withhold tax at source when making these payments. So on the last occasion, we had made this submission. So the Learned Revenue Council had said that now they're seeking to contend that the case of engineering analysis would not cover these payments in question. So my submission on the last occasion was, on the one hand, when the decision was favorable, the CIT appeals relied on the Samsung order. Now, since Samsung has been reversed, it may not be appropriate to say that engineering analysis would not cover. It's the same decision. The matter was carried in appeal from this honorable court to the Supreme Court. So the bench had asked me to just place a short note showing how the relevant para numbers. I'm fully ready.
My lord, so far as. Please. Please.
My lord, serial number 27.1. Kindly detag the matter from the batch matter. Yes, ma'am. One.
Why do you say so?
The question of law raised by us is different from the other batch matter, my lord.
Not even that is royalty only. But if they want it to be heard.
We want that.
The issue is royalty only, then I leave it to my lordships.
My lord, it's there is yeah, my lord. Yes.
28. Serial number 28.
Lordship, appear for the respondent.
Your Lordship, page number 5, question number 1 to 6, my lord, relating to transfer pricing, the questions of law has been framed, my lord.
No, sir, please.
It is not yet admitted. Not yet admitted, miss.
Thirteen 1/2025. Serial number 29.
Here for appellant, my lord.
Yes.
Your
29.
Lordship, questions of law are at page number 6, my lord. The identical questions, my lord, in assessee's own case in ITA number 10 of 2019, questions are admitted, my lord. The similar questions, my lord.
Only thing is, I'll just point out, my lord,
that matter notice was not given to us. But the thing is, there are two issues. One is, what is the most appropriate method to be applied to my transactions of import under transfer pricing? That issue, the tribunal says, for earlier years, department has accepted the orders and therefore has granted me relief this year. Now, years in which tribunal has granted relief to me on that issue, also some years they have not filed appeals before this honorable court. Supreme Court, my lord, in Excel says that an issue which is permeating through assessment years, although strictly res judicata may apply, the department cannot take flip-flop stands, that some years you don't challenge, some years you come before the High Court. I'll just show Excel. That is one year, one issue. The other issue is advertisement, marketing, promotion expenses. The tribunal relies on the Delhi High Court order in Sony Ericsson, which is my lord's judgment. Whether my lord can take any different view, they can only say that the matter is pending in the Supreme Court.
I was part of the bench?
Yes.
With Justice Khanna.
That's right. That's the same issue that's been relied upon by the tribunal. Of course, the department has filed an appeal before the Supreme
Court.
That's pending in the Supreme Court. No date fixed, but can we keep this matter pending until Supreme Court decides? Otherwise, as things stand today, the matter is issue is covered.
In terms of Sony Ericsson?
Sony Ericsson.
What do you say, Mr. Sanmati?
Your Lordship, as far as question number A, B, C, and D, my lord, the identical question is pending before this honorable court in assessee's own case in ITS 70 of 2019. As far as question number E and F, my lord, the matter is pending before Supreme Court, my lord. Your Lordship judgment in advertising and marketing, that issue is pending before the Supreme Court. Let the matter be deferred for some time, my lord.
Can be deferred if the matter is on board before the Supreme
Question
Court.
number E, because the SLP.
We don't know when the Supreme Court is going.
That has a bearing, then we defer it, Mr. Sir.
I'll leave it to your lordships, but we don't know when the matter will be decided by the Supreme Court. These matters, AMP issue is there in so many appeals that are there before.
You can say that if ultimately we agree with you and follow that, but this should also go there.
That's all.
Lordship, let the matter be admitted, my lord, because the connected matter 70 of 2019 is admitted.
We will also have an
Even if it is
opportunity before the
admitted,
Supreme
my lord.
Court if these matters go to the Supreme Court, AMP.
Let's see, we'll see it. I think we'll also see, let's have it after 4 weeks, then we'll see what is the, that's an admitted now.
It is leave is granted, my lord.
Leave granted.
Yes, my lord.
Just say that re-notify just after 4 weeks.
Yes,
We'll see them.
Very well.
9.
These matters, my lord, there are connected appeals of the SSE. This may be tagged along with those. There are 2 other appeals of the revenue which are not admitted on these very same issues.
Okay.
I'll give the pass on the numbers.
Just
They may all come on
the
the
same SSE,
same as
28 now.
29, my lord.
29,
29.
Okay.
I'll pass on the numbers. I'll
Say that, then we will not be giving a date then. If those are not dated,
those have to come up they may come up in a week or so in any case.
what appropriate would be, we give a date here.
Very well. When they come up,
Okay, they will have it there the same.
very good.
Just give a date here.
Please, my lord.
Great.
30 adjourned, 31 adjourned, 32, 32. Vishira Amarnath.
My lords, I appear for the respondent in this matter.
Okay, for the appellants, my lords.
Which is- Let's see this appeal. Yes, sure.
My lords, on the last date of
This came last week.
last week, my lords, whether instructions was sought, whether committee would be there in place, because as of now, the submission of the learned counsel for the respondent was that the committee is no longer in existence. In view of that, the board had issued a circular, my lords, if I may pass this. that there will be a manual processing declaration under the said scheme, my lords.
So the consideration.
Yes.
Now tell us one thing in terms of these directions.
Yes, my lords.
It's almost a direction that you will make the payment.
That's that.
We'll make payment.
They'll make the
They
payment.
make the payment. Then. Now, what need to be done in terms of this circular?
Pardon, this appeal, the matter might be remanded to the committee, my lords, for first consideration, if at all, my lords.
No, consideration is after this 31/1/2020 is quashed.
Yes,
Consideration to what extent?
that's only with respect to the show cause notices that were issued, my lords.
Yes.
Only with respect to the show cause notices issued.
But tell us, ma'am, one thing,
Yes.
once a show cause notice has been set aside, but the show cause notice, the order has been passed.
My lords, if I may, I'll just give a brief background of what happened once. The SSE was actually subject to an audit inquiry, pursuant to which certain audit paras were raised. And there was a specific quantification by the department calling forth the SSE to pay under that quantification. All that the scheme requires is a written formal communication of the demand from an SSE. If I have to pay under the title audit, investigation and search. Now under SVL DRS, my lords, for the sake of administrative convenience, they had marked 30/6/2019 as the cutoff date. Anything before this period is eligible if there is a quantification. Any payment after that period is not eligible. There's no quarrel with this proposition. My audit is also before the cutoff date, again not disputed. Their only contention seems to be that the show cause notice in this case, my lords, same issue. Show cause notice came on 30/4/2020, which is after the cutoff date. Now, my lords will appreciate that all tax proceedings, my lords, are dynamic in nature. If there's a show cause, I will reply, then they will agree or not agree. If they don't agree, there's a demand consequentially. This process will continue, which is why there is a cutoff date. My lords, the circular that I had relied upon before the learned single judge clearly captured such a dynamic process, and the circular was categoric in saying that in case there is a subsequent proceeding, maybe from audit it became show cause, from show cause it became order, that cannot be taken into consideration as long as I meet with the requirement of a quantified demand before the cutoff date. This is the only requirement under the scheme, because the scheme, my lords, is to do away with legacy disputes because GST came. It was also a collection mechanism for the government. My lords, this court, several other courts have already taken a stand that the scheme is beneficial in nature. Therefore, circulars, if any, are all in favor of the SSC. This was appreciated by the learned single judge when he was passing the order. That's why, my lords, though there is an obiter saying that the rejection order is unreasoned, etc., straight law on the point has been considered and given benefit of, my lords. This is where we stand. Now, their only prayer in the writ appeal seems to be that this rejection is wrong in view of the show cause notice, which obviously made the demand much higher, and that the SSC is required to pay under the show cause notice under the normal scheme. Benefit under this SVL DRS scheme will not apply is their only contention. Now, my limited two arguments are like this, my lords. One is this honorable court is only exercising the same powers under 226, even though this is an intra-court appeal. With great respect, I say this, my lords, the learned single judge had noticed the fact that there is law in my favor, despite the order not saying so. Therefore, my lords, when law is my favor, and I have waited 2 years even after the judgment came, They filed an appeal, did not comply for over a year, and I have filed contempt proceedings which are still pending. My lords, I have demonstrated my bona fides to make this payment at every juncture. Now, my only request before this court is if we are remanded back, this will again go, my lords, for 2 more years. The intention of the government in collecting that money under this scheme is thereby defeated. It's only a question of 35 lakhs. I'm ready to make that payment. Had this time schedule in the order been complied with, we will be long over this.
So the only thing is they will issue a discharge certificate.
They will issue
Yes.
discharge certificate. I'm entitled to that because I comply with every other condition in this scheme. Now, my lords, may kindly peruse the writ appeal for a moment. Every decision that they have cited are directly not applicable to this case. They are saying that there are judgments maybe from other forums where show cause notices have been issued, but there was no quantification. They are relying on cases where there is voluntary disclosure, where the assessee may have quantified. Those are not applicable here. My lords, also, what is the ultimate relief that has been claimed for in the writ appeal? The writ appeal is simply asking for the show cause notice to be applied. They are not even asking for a remand to this manually constituted designated committee. That's not their prayer. That is something that they have improved upon their case today, that they want this to be remanded. Very respectfully, my lords, if this approach is granted, then there will be no end to this litigation. Because again, the manual committee will say that this circular does not apply. We have our doubts because of the case cited. They don't have any equitable jurisdiction, admittedly. They are again the department speaking for the department.
Now, this circular is after those cutoff dates.
The circular was issued as a clarification about how the scheme should work. I'll just take my lords through the circular. The issue will become clear. My lords may kindly take page 183 of the appeal memorandum. (182) is the relevant annexure. This was an annexure in my writ petition as well. Annexure S of the writ at page 183. My lords have it. My lords, may I please read para 5 at page 183. This is directly on the point. For the purpose of eligibility under the scheme in some of the categories such as litigation, audit, inquiry, investigation, etc., the relevant date is 30/6/2019. However, it may so happen that the facts of a case may change subsequently. For instance, in a case under audit, investigation, inquiry, where the tax dues have been quantified on or before 30.
Where are you reading?
This is page 183, my lords, of their appeal memorandum.
Annexure J.
Annexure S.
Yes.
S. Annexure S to the writ. My lords, the difficulty is I've been given a copy before compliance. I don't know if the
That's the difficulty. 214.
I believe it's 214, my lords. 214.
214.
Annexure S is 214.
Please.
215 is the 11th page number.
Please.
Yes.
In this, I was reading para 5, my lords.
Yes.
For the purpose of eligibility under the scheme in some of the categories such as litigation, audit, inquiry, investigation, etc., relevant date is 30/6/2019. However, it may so happen that the facts of a case may change subsequently. For instance, in case under audit, investigation, inquiry, where the tax dues have been quantified on or before 30/6/2019, a show cause notice is issued after 30/6/2019. Similarly, a case which is under appeal as on 30/6/2019 may attain finality in view of the appeal period being over, etc. It is clarified that the eligibility with respect to such a category in such cases shall be as it was on the relevant date, that is 30/6/2019. My lords, in view of this, the learned single judge had allowed the writ petition. And my lords, how SVLDRS also operates as a scheme is, I file my Form 1 stating that this is my self-assessed tax demand under the scheme. They then in turn issue Form 2, which is an agreement with my Form 1 calculation. Now, once Form 2 is issued, my lords, I have two options. I can either ask for personal hearing if I differ with the quantification, or I can just say that I'm in agreement, waive the requirement to personal hearing, and go forward. When they go forward, they issue me Form 3, which is the final quantification. I come forward, make payment, pursuant to which discharge under Form 4 is issued to me. We had come as far as Form 2, my lords. I also waived my requirement. Therefore, there is no question of me not being heard in the rejection. I asked for a waiver. Subsequently, my lords, they have found out that show cause notice has also been issued by another authority, admittedly, that is from the Directorate of Intelligence. As long as there is no dispute that it is the same dispute, same period of taxation, same category of service, my lords, I come under audit. And this circular is squarely in my favor.
You are not disputing the payment to be made by you.
Not at all.
You're not contesting.
Not at all.
So what remains, tell us now, why a fresh consideration?
My lords, as of now, my lords, they have not made the payment regardless, my lords.
They will, that's the direction of the learner single judge.
My lords,
You will issue form, they'll make payment, you will issue discharge certificate.
my lords, there was an investigation that was carried out in which there was several mismatches, my lords.
So what is the liability?
Total liability stands at, my lords, if I may.
According to her, 35 lakhs.
My lords, according to us, it's well beyond 35 lakhs, my lords. The total liability stands.
How much? How did you quantify 35 lakhs then?
My lords, the show cause notice, in fact, details the manner in which they've arrived at the calculation, my lords. At Annexure B of the writ petition.
Let's see that. How much they have quantified?
My lords, if I can just say this very respectfully, even the committee will not be able to go into the merits of the show cause notice because this is a committee constituted under the scheme. Show cause notice is issued by a different authority. Even if the committee felt, my lords, that the show cause notice needs to be looked into, they don't have the powers. I will be back before this court on that ground, my lords. Because if the committee says show cause notice has to apply, under what provision? Committee is constituted under the 2019 scheme, also dissolved as per 2019 scheme. Now they are saying we will manually reconstitute. That is only if there is a fault found by this honorable court in the manner in which the scheme has been implemented. Whether the show cause notice is right or not is a different mechanism altogether. That is governed by the 1994 Finance Act because it's a service tax matter.
Let's see that the order which has been set aside by the learner single judge.
Please.
(31) 2000.
2000, the annexure. Annexure A, my lords, at page 55, my lords. A of the writ petition, which is page 55 of the entire compendium.
Where is the liability fastened upon? Where does the
Annexure B,
liability-
my lords, the show cause notice, in fact, talks about the detailed liability aspect, my lords. That is Annexure B, my lords. Notice to show cause. That's 34/2020, my lords.
How much is the liability you have fastened upon?
For differential service tax payable is 1,68,45,622, my lords.
How do we get that?
My lords.
Which page is that?
Page 50, my lords, they go in detail, my lords. If I may, my lords, analysis and quantification of service tax starts from page 25 of the said annexure, my lords.
Show cause notice runs from 99 to which page?
It's 90, 50,
Yes,
57, my lords.
140. Is the liability more than 35 lakhs?
It is. It will be. For the simple reason, my lords, the scheme allows me certain discounts if I am voluntarily paying under the scheme. Therefore, my lords, the scheme had two categories. One is if the demand is more than 70 lakhs and one is if the demand is more than 50 lakhs. And certain percentage of deduction straight away in the demand, no interest, no penalty, all of this was given. Therefore, my lords, for obvious reasons, show cause notice amount will be higher than what I have liable to be paid under the scheme. But my learned friend is like.
So tell us one thing then.
Please.
Then why don't they quantify it? So you are in a way contesting it.
Meaning?
See, whatever they would show cause notice says higher amount.
Please.
You have replied to the same,
Not to the show cause notice.
not to the show
Not
cause.
to the show cause.
How would they determine what is the liability? Suppose they say that whatever they have prescribed in the show cause notice, that would remain? Will that be to your satisfaction?
My lords, I'll put it this way. Had I succeeded in my SVLDRS application, the discharge certificate then washes away any subsequent proceeding for the same dispute. Show cause notice would have gone on its own. Therefore, after I submit my application, if they come up with this reason that you have to contest the show cause notice and not rely under the scheme, they're defeating the purpose of the scheme. Scheme was meant to say, let us have a finality to the dispute. Somebody has to lose, my lords. At the end of the day, the government admittedly decided to take a hit by giving me deduction straight away. The government decides that because GST is in place, all the legacy disputes, the scheme is called Legacy Dispute Resolution Scheme. Legacy disputes need not survive is a policy decision that they have very consciously taken. That being said, my lords, is it now open to them to say that I will reject the scheme benefit because I have arrived at a subsequent quantification, which may be higher? That cannot be the reason why scheme can be rejected. Scheme says 36/2019.
Purpose for the scheme.
There is, my lords, there is, because the large amount of disputes that got settled through SVLDRS, a handful of them have reached this honorable court. Otherwise, the collection by virtue of SVLDRS was much higher. Let us look at it this way, my lords. Tomorrow, suppose the SSC is able to secure an order lower than what the audit paras had quantified. The converse cannot be true. I cannot then change my application and say I want benefit of the lower quantification. I have stuck to a cutoff date. 36/2019 is my cutoff date. If there is a lower revision also, I am not entitled. If there's a higher revision, they are not entitled. This is administrative convenience to have a cutoff date. If my learned friend's quarrel was, show the manner in which I had applied under the SVLDRS scheme has some error. Maybe my form 1 had an error, maybe my form 2 had an error, something like that. If that was their case, I would be with my learned friend on that point. But here we are talking about a scenario where they have woken up much later, 20s when they have come up with a show cause notice, saying that we missed out a few things, may or may not be true, but now you pay because of that. And it's only a show cause notice, it's not even an order.
Tell us with that view, with that background, what is wrong with the order of the learned single judge?
My lords, if I may, my lords, the entire show cause notice narrates the manner in which they've conducted themselves, my lords. So, in fact, they've not failed to adhere to the basic standards or.
But what she's contesting is the very show cause notice itself.
Yes, my lords. Ideally, they should respond to the show cause notice, then contested at that juncture, my lords, because there is clear aspects of misdeclarations being done. These are severe, grave errors, my lords. On the face of it, they can't take an embargo, they can't take a cover under the guy saying that the time period is going to be lapsed. And after which they've approached the issue the show cause notice.
Whatever the benefit under the scheme need to be given.
My lords.
Are you giving the benefit of the scheme?
My lords, we would have given the benefit of under the scheme if they were true to their words, my lords. The show cause notice, if I may, my lords, read the relevant paragraphs, my lords. Why the show cause notice came to be issued, my lord, that has to be looked into also, my lords, at this juncture.
Let's see this circular which you have now issued, which you have now placed.
Now issued, yes. 17th March 2021, my lords, issued the manual processing of declaration filed under SVLDRS 2019 in order to comply with the directions of the Honorable High Court, my lords. References are being received in the board from the CGST zone in respect of writ petitions filed by aggrieved declarants before various Honorable High Courts against the decision of the concerned designated committees taken under Sabka Vikas Legacy Dispute Resolution Scheme 2019. The cases in which the Honorable High Court has decided in favor of the declarant and remanded the matter back to the concerned designated committee for fresh considerations are referred to the board for grant of permission for manual processing of the subject declaration so as to comply with the directions of the Honorable High Court. In this regard, it is to inform that the Office of DG Systems have expressed an inability to provide the facility for electronic processing of the subject declaration and suggested for manual processing. The matter has been examined in the board. It is hereby clarified that henceforth all such references for grant of approval of manual processing of declarations need not be made to the board, and such cases can be processed manually by the concerned designated committees upon the fulfillment of the following conditions. The order of the Honorable High Court has been accepted by the concerned commissionerate. The learned ASG and standing counsel who had represented the case before the Honorable High Court has opined to accept the said order of the Honorable Court. All such declarations that have been processed manually may be reported to the Office of DG Systems by 15th day of the succeeding month for purpose of record.
My lords, if I
My lords,
may.
this question arose, this circular was placed before this honorable court in view of the fact that on the last occasion, my lords, there was a specific submission that the committee is no longer in existence. Even if the matter is remanded back, the committee, there is no committee. In view of there being no committee, the matter cannot be remanded back. Hence, I placed this particular circular where there is manual acceptance or manual processing of the issue, my lords.
My lords, para 1 of that circular simply says it is applicable in cases where the High Court has taken a view in favor of the SSC and remanded the matter back to the committee. In this case, my lords, first round of litigation before the learned single judge, High Court took a view in favor of the SSC, did not remand the matter back to the committee. Second round, my lords, in appeal today, if my lords were to agree with the revenue and remand the matter back to the SSC, the circular is not applicable because it's not a matter in which the High Court has decided in favor of the SSC. This is not meant for adjudication on substantive issues. This circular,
No, he said ki now if the consideration need to be in terms of this.
I'm only saying this much. This circular only enables such cases where there is a view in favor of the SSC and then there is a remand. If there is now a view in their favor and then there is a demand for re-adjudication, this circular will not help them because this remand is limited only for, suppose there is a need for issuance of discharge certificate, I am supposed to make a payment. That is why the committee has been brought back. The wordings in this circular, my lords, is if the High Court already decides the matter in favor of the SSC and then there is a
How do
remand.
we get that?
First para, my lords. The cases in which the Honorable High Court has decided in favor of the declarant and remanded the matter back to the concerned designated committee for fresh decision are referred to the board for grant of permission, etc. My case is,
Now this manual processing of the declaration is to the extent of the discharge.
please, because there can't be any other interpretation here. If the High Court decides to be in favor of the declarant, that is petitioner before the learned single judge, then remanded the matter, this manually constituted committee would come into picture. They'd receive,
Or the discharge would automatically follow.
please, they'd receive the money. Somebody has to receive the money because this was completely automated. The reason that they have been made manual right now is I could not make a direct payment to the RBI treasury. Otherwise, when I click my options, my lord, that payment directly goes to the treasury. Discharge certificate is to be issued online. Since nobody is there to collect and receive, they have been brought back by virtue of this circular. They are not empowered, at least under this circular, to go back into the merits of my application. Because the direction is very clear. It has to be a remand in my favor.
It says for fresh decision, my lords. Clearly remand the matter to the concerned designated committee for a fresh decision. Which means it's a fresh consideration, my lords. Para number 1. I refer to the board for grant of permission for manual processing, my lords.
Fresh decision only when the remand is after a decision in my favor. It's not an open-ended remand.
What she is highlighting is this decision concerned designated committee taken this, the cases in which High Court has decided in favor of the declarant and remand the matter back to the concerned for a fresh decision are referred to the board for grant of permission. So it's like this, there is a conclusion of the High Court in favor of the SSC.
Yes.
Now what follows is the discharge.
My lord,
Previously discharge was through the committee,
Please, through online.
through.
through online. Now what is being saying is now you will do it manual processing. Ultimate, very well, we don't mind. See, it's like this.
Yes.
Maybe possibly she would not mind. So you are proceeding on this premise. High Court has concluded in their favor. Okay, now only thing is the discharge need to be followed. That is under this.
That is the interpretation of the learned counsel for respondent, my lords. And
It appears so.
it appears so, my lords. So the language seems to,
It is not an open-ended remand that is being
my lords,
contemplated under
it's for,
this.
Not open-ended. It is this conclusion by the High Court in favor of the SSC. Now what follows is
Discharge.
the discharge. Now in what manner the discharge need to be undertaken? Previously it was this, now you will do this. That is the manual processing.
Please, that's all I'm also saying. My lords will appreciate. Learned single judge also said this one. There was no reference to this circular because nobody had brought it to his attention in
But there would
2021.
be a discharge. For the discharge, this need to be followed.
For the discharge, this needs to be followed. To that limited extent, the learned single judge's order can be modified incorporating reference to this circular.
my lords,
Oh, that's what she is saying
That
is
is-
very well. She is also agreeing with you that this, since you have issued this,
yes, ma'am.
now this committee has to undertake and mind it. The committee will only undertake what has been empowered to the committee under this circular.
My lords,
Nothing more.
my lords, I beg to refer to that point, my lords. I believe it's for fresh consideration, my lords.
What fresh?
The entire aspect.
Let's be very clear, this
My lords,
circular is
let-
not fresh.
It's not.
My lords,
This circular is not fresh.
fresh, I understand, my lords.
This is from a stage for a particular result.
My lords,
That
if it
result
is,
is discharge certificate.
my lords, if I may be permitted to take instructions on the particular circular, my lords, on this particular circular, if there's subsequent.
We don't know this, you have filed it.
My lords, I might be permitted to take.
We will say so, the order of the learned single judge is modified.
My
When it
lords,
comes to discharge, this would be followed.
My lords, if I may be granted 2 days' time, my lords, I'll do,
Will pass over, get your instructions.
my lords, of that.
Pass over.
Please. Great.
You're clear? She says very well, this circular is there, this is only to the extent of discharge,
Yes, my lord.
let them do it. Pass over.
Yes.
33, 34, 35 adjourn. 36 adjourn, 37, Shri Shiva Prakash. 37. Shiva Prakash.
That's my appear for respondent number. May I request for an pass over my notes?
Which one?
37.
I will hear it. You appear for whom?
Respondent number 1, my lords.
What about the other respondents? Okay, pass over.
That is dispensers. 38 adjourn, 39, Shri Sushal Tiwari. 39,
Appearing for the respondent, Your Worship. It's a transfer pricing matter, Your Worship.
This transfer price.
Please.
We also, this is the same. We'll await those.
Please, my lords. Coordinate bench decision.
When a counsel for the appellant states that as the matter relates to transfer pricing and in view of the remand made by the Supreme Court, one appeal is being heard by a coordinate bench of this court. And appropriate shall be to await the outcome of the said appeal. The matter be adjourned, Full stop. Accordingly, list this appeal in due course.
Publish.
40, dispose 41, Raviraj. 41,
Can we have it on second or third week of November, this?
Very.
Just
I'll
simply
just take my date.
re-notify. Just simply re-notify.
I give my convenient date. my lord.
Pardon?
Can I give a date convenient to my?
Very good. We're just simply re-notifying it.
Your lordships are not fixing a date?
We'll give a date.
Very
We'll
good.
give a date. Just give a date after.
But 25th November, we have.
Please. Just say simply re-notify.
25/11.
We'll file our submissions also by that time.
Next.
42, 43 adjourn, 44, Shri Ashok GV. 44.
The respondents. The appeal. Appear for the respondent. The appellant is a corporation that's wholly owned by the state. The tribunal and the order below the tribunal appear to have gone.
Who appears for the appellant?
Well, one Mr. Ashok appears. I had spoken to him in the morning. And I'd also spoken to the
See, the position of law is this. Purely a writ court in 226 can look into the reasons. But what reasons we find in this case is surely it could not have been allowed. Even the delay. See this. Page 136.
My lord, apologies. I appear for the appellant in this matter.
Very interesting. Ma'am, you appear?
Yes, ma'am.
Yes, what do you say?
I got instructions to take time because apparently we are referring this matter to internal committee.
You withdraw it and internal refer it.
There is little controversial, I mean, we are deciding whether it can be referred to the internal committee or not.
We will not
So-
allow all this.
I just seek for an adjournment of week's time. Madam.
Hmm. See, what does the court holds? That there is the order which has been challenged is of 2019. What was the reassessment order which was not challenged is of 17. It should have been actually 17 which need to have been challenged.
Yes.
That remained unchallenged till date.
Yes.
So if that be so, where is the question of challenging an assessment order or a reassessment order? So that went unchallenged. Dismissed, and the reasoning given for the condonation is at 136.
Hello.
That's all. And that's the reasoning given. Maybe we'll have it, have it next week, get your instructions.
Please.
At the request of counsel for the appellant, renote, to take instruction, re-notify.
8:10.
Watch out.
Passed on matters. Serial number 12. Serial number 12, Shri Satyanarayana, T.R. Satyanarayana.
Yes. इससे पास हो
27.
Lord, case where the tribunal has relied upon engineering analysis.
Just hand over the note. I want, just for the benefit.
Lord, brief case of the revenue is
Yes.
My lord, before starting, my lord, may I take my lordships to the case of, my lord, the judgment in the case of engineering analysis, just to show my lords, my lord, which are the categories of cases which have been considered by the Honorable Apex Court. Then, my lord, if a finding is given by the tribunal or any authority that in a given case,
Can you to switch off this? Just asking. Yes.
My lord, page number, para number 4, my lord. The appeals before us, may I read? Para 4. The appeals before us may be grouped into 4 categories. 1. The first category deals with cases in which computer software is purchased directly by an end user resident in India from a foreign non-resident supplier or manufacturer. 2. The second category of cases deals with the resident Indian companies that act as distributors or resellers by purchasing computer software from foreign non-resident suppliers or manufacturers and then reselling the same to resident Indians. 3. Concerns cases wherein the distributor happens to be a foreign non-resident vendor who, after purchasing the software from foreign non-resident seller, resells the same to resident Indian distributors or end users. 4. Includes cases where computer software is affixed into hardware and is sold as an integrated unit equipment by foreign non-resident suppliers to resident Indian distributors. So in all these 4 cases, my lord, what is important is, my lord, there should be a sale or purchase of a software. Now, my lord, wherever in cases where, my lord, the software.
What did you say this? No, you said now after this, what was your submission?
My submission is, my lord, all these 4 cases, my lord, deal with software purchase.
That's right.
Where, my lord, software services are rendered by a foreign entity, that would not get covered in these 4 cases. If the revenue is able to show, my lord, that the payments have been made towards availing software services or related, my lord, matters, then it would not get covered by this decision.
Okay.
So there has to be a purchase of an, you know, the software, computer software. If all the four categories deal with purchase from a foreign entity.
From a foreign
entity, and not cases where services are availed or payments where the payments have been made for availing the services of software. I'll demonstrate, my lord, in this particular
case. What is the difference between the two? One is you say that all cases where software purchased from a foreign entity. That's one.
Please.
What is the second example you are giving?
My lord,
not applicable, at least this case is not applicable to whom?
My lord, where the foreign entities are providing infrastructure facilities and where it is owned by the foreign entities. My lord, when it is purchased, the purchaser will be entitled to use it, my lord, as an owner. Whereas, my lord, availing, they will be having the software, they will be owning it. And the agreements will be as an owner and the user of the product.
Owner is who? The foreign entity?
Foreign entity.
User is the Indian entity. No, but
now, my lord, I'll take my lordships to the particular, my lord, example in the same case. Not example, my lord, page number 24.
But you say foreign entity infrastructure. What is that?
My lord, related to software.
Yes.
My lord,
now,
what they say is,
what the SSEs here? Now,
cloud computing, you know, where Facebook space is used for advertising. And the Indian user, my lord, will not own it. He is only, my lord, making the payment for having used it.
That's right. He is an intermediate. It's basically a platform given by an intermediary.
Please.
So that way you are saying he's not using
purely,
the software.
Purely technical use, my lord, which I'll take my lordships through the finding of the office, you know, assessing authority.
Just tell us what are the SSEs doing here?
SSE, my lord, the finding is, my lord, observation is in page 24, advertising through Facebook platform.
Oh, they are advertising through.
Facebook
So are you
platform.
saying this advertisement does not involve usage of software?
Because he doesn't own it.
And they doesn't own it. And now this judgment of the Supreme Court,
I am only
it's the
saying
software per se which has been purchased.
purchased.
And that software is being used not for advertising, for its own purpose.
Own purpose.
Or for
Which
running any
could be for
program.
advertising also.
Pardon? It can be for running a program, for operating certain services. Let's assume for a moment, IRTCE, you know, the railway where ticket booking is there. I purchase the software from out and use it for my purpose for ticket booking. So some railways imports it or purchases it. Is different from a platform being used for by a SSE to advertise itself.
When I own it, I can give it to others also for use. Not only my use, similar concerns, who would want to use it?
Okay. Okay. Now, how does the ITAT deals with it?
ITAT simply follows page number.
Findings are at page 82.
Page 89. Sorry, my lord, I'll go to the finding itself, page number 98. Para 20.
Give us the finding.
My lord, ink page 98. Para 20. Para 20. In the case of Engineering Analysis Center of Excellence, Private Limited, the issue related to issuing of license to use software, that is, the software purchased by a person shall be used by the buyer for his own business. Since the license was granted without parting the copyrights attached to the software, the Honorable Supreme Court held that the payments received by the non-resident software companies cannot be taxed as royalty under the provisions of double tax avoidance agreement, and hence there is no requirement to deduct tax from source from the payments made by them resident SSC. Now, my lord, in contrast to this,
So now, for what purpose this issue has arisen? Is it for
certain
TDS?
payments.
It is for TDS purpose?
Yes.
It's for TDS purpose.
Yes. When I made the
TDS
payment,
purpose.
should I have deducted tax?
If it is not royalty,
Yes.
it is no TDS.
There's no
TDS. My lord, royalty, my lord, has been defined. My lord,
Non-residents
definition has
cannot
been,
be taxed as royalty under the provisions. And hence there is no requirement.
my lord, definition of royalty is in page number 29.
But suppose if it is a royalty,
It has to be.
yes.
Then the payees, the crux of the issue is, if it is royalty, the payees are deemed to have an income arising in India under the Act. And therefore, when I pay that amount to them,
TDS need to be deducted.
I need to deduct it because admittedly, none of the payees have what is called a permanent establishment in India. So therefore, whatever I pay them, if it's not royalty, it does not constitute business income under the Act. So that is not their case, that's nobody's case. So the only issue is whether these payments amount to royalty. For it to amount to royalty, there should be a right in the copyright of the software being transferred to from the payee to the payer. If I don't get that right in the
But tell
copyright,
us one thing, is the copyright getting transferred here? Insofar as the usage, at least what we have understood you is, you are advertising, na? They are advertising, you are advertising on the.
No, they are using the space.
okay,
They are
precisely.
utilizing this.
I'm paying Facebook and Amazon and another entity which has bulk emails. I pay them a particular amount as license. In consideration for that license, they allow me to host ads on Facebook or on Amazon. There's some cloud computing. So I pay for the license, which allows me to use the platform.
Do you also enter agreements with the third party, further third party, to utilize that space which is meant for you for advertisement?
There are what are called end user license agreements, which are EULA, which
You
are
are the end user.
yes, I'm the end user, which prohibits me from entering into or further alienating. I don't.
It's prohibits.
Yes, that is in fact even the case in the Samsung, which had arisen before this honorable court.
So, okay. So what you are saying, you are using it and okay. So according to you, it's what you are paying is not a royalty.
Not a royalty.
If it is not a royalty, then no tax deducted source.
Not deductible at source.
But tell us one
Milord,
thing.
definition of,
Where
I'll
is
just,
the right in a copyright getting transferred?
Milord, I'll just, what is important is the definition of royalty, Milord. The definition of royalty is as per para 3A, I'm reading from, Milord, page 29. With regard to the definition of royalty, as per the paragraph 3A of Article 12 of India, US DTAA, the term royalty is described is as follows. The term royalties as used in this article means payments of any kind received as a consideration for the use of or the right to use any copyright of literary, artistic, scientific work, including cinematography, films or tapes for radio or television broadcasting, any patent, any trademark, design, model, plan, secret formula or process for the use of the right to use industrial, commercial or scientific equipment other than an aircraft or for information concerning industrial, commercial, scientific
Can
experience.
it be a royalty on a prima facie, analyzing it? If I write a book, I give it to a publisher. He gives me, that's royalty for me. And ultimately, whatever he is earning through sale would be his, that's between understanding between them. But here the person, at least the foreign entity is creating a software and selling here or selling the space here insofar as he is concerned. So ultimately, all rights in the work continues with the foreign entity. So the usage of space can be considered as a royalty.
Milord, that has to be appreciated, Milord. With reference to, Milord, explanation 2.3 of section 916. I'll just take my lordship's to income deemed or accrue or arise in India. Section 9(1).
In fact, the tribunal also
7.
has, I'm sorry, the tribunal has at length examined the agreements entered into by me and Facebook and given its own findings just above in the same order. And then it also says it's covered by engineering.
We'll do one thing, Mr. Aviraj.
Please.
Let's read IT-80 on that. We'll have an idea.
Please.
What really prevailed with the.
Page 82 may kindly be seen, para 10, that's where the findings commence.
Let's see the facts also.
Yes, please.
Milord, before going to that, Milord, may I read 2 paragraphs of the AO's finding, Milord, observation. All the.
The tribunal must be dealing with that. Let's read from the page 67.
the SSC has filed these appeals challenging the common order dated 17/3/20 passed by CIT Appeals, Bengaluru, confirming the demand raised under section 2011 of the Income Tax Act and interest charged under 2011A of the Act for financial years 14-15, 15-16, 16-17, relevant to the assessment year so and so. All these appeals, the SSC is challenging the validity of demand raised under section 2011 and interest charged under 2011A. The facts relating to the issue are stated in brief. The SSC company is engaged in the business of dealing in home decor products. It sells its products mainly through online marketing. Hence, the SSC has placed its advertisement in the platform of Facebook Ireland. It has also used bulk mail facility offered by Rocket Science Group USA. The SSC has also used Amazon Web Services offered by Amazon Inc. USA, which is in the nature of providing information technology infrastructure on rental basis. All these three payees are non-residents. The AO noticed that the SSC has made payments to these non-residents. Hence, he conducted a survey operation under section 133A on so and so to examine compliance with TDS provisions. During the course of survey operation, the AO noticed that the SSC company has made payments to non-residents towards advertisement and marketing expenses without deducting tax at source. The AO took the view that the SSC is liable to deduct tax at source from the payments made to non-residents. The AO examined the taxability of above cited payments as per provisions of section 916 of the Act, more particularly under clause 3 and 4A of explanation 2 to section 916 of the Act. The AO also observed that these payments have been examined as per DTAA provisions. However, AO has made reference to DTAA provisions while examining the payments made to AWS. Since there was a failure to deduct tax at source by the SSC, the AO treated the SSC as SSC is in default for all these years under consideration and raised demand under 201 of the Act and also 201(1)(a). The details of payments made by the SSC to three different non-residents are tabulated below. Facebook Ireland, Rocket Science, Amazon Services.
Okay.
Demand under section 201 or 201A.
Just see that demand made to Facebook, payments made to Facebook.
Payment made to Facebook, 26 crores for 15/6.
Okay, I think we can avoid this. Now, come to page 72(6.6).
The case of the AO is stated in paragraph 4.11, 4.1 and 5 of the assessment order dated for the assessment year 15-16. Identical reasoning has been given for other years also. For this payment, the AO has also referred to the definition given in India-US DTAA for royalty and fees for included services. The relevant portion of the AO's order is extracted below. There will be sites of the SSC company wherein the data connectivity and networking is provided by the AWS. Generally, every site has a router being placed in the premises for the data communication purpose. It is clear that the services provided by AWS also includes providing the routers and the data connectivity and networking. The SSC company, by relying on the decisions of the ITATs, is wrong in claiming that there is no involvement of any human intervention at any stage and that entire process is fully automated technique. Had such been the case, there would not have been any separate mention for the provider to ensure that the facility is adequately staffed for the provision of all services and that the provider employees, agents, and subcontractors have sufficient skill, expertise, and ability to perform their duties in a competent and professional manner. This shows that the SSC is in fact not only aware of the technical expertise required in obtaining data housing services, but also appreciative of the quality of manpower to be employed for such technical services. The AO extracts explanation 2 to 916 of the Income Tax Act. The AO extracts, that is in 9.18. that is in my lord.
But tell us one thing,
Please.
these three entities on whose sites or you are advertising it, they may be having similar agreements with other entities also. That's right. It's not exclusively to this SSE. There may be other people also where they are hosting advertisement. everything.
Being the owners of.
How can that be construed as a royalty? See page 70.
My lord, section
Thus, the
9.
held that the payments made all the three companies in the nature of a liable for deduction and tax at source. The royalty is then the exclusive right of yours to use that particular, you can say work, whatever you may call it, as a copyright, that's it. Then possibly royalty. But here, when they have when the non-resident has similar agreements with the other entities, can it be construed as a royalty?
My lord, section 916, explanation 2.
Yes.
Reads as under, my lord, explanation 2. For the purposes of this clause, royalty means consideration including any lump sum consideration, but excluding any consideration which would be the income of the recipient chargeable under the head capital gains for 1. Transfer of any rights in respect of a patent, invention, model, design, secret formula, process or trademark of similar property. 2. Imparting of any information concerning the work of or the use of a patent, invention, model, design, secret formula or the process or trademark of similar property, use of any patent, invention, model, design, secret formula or process or trademark of any similar property.
But is an exclusive use. If use, would that mean an exclusive use? Without such being used permitted for other third parties. Just show us that.
What it says is, for the purpose of this clause, royalty means consideration including any lump sum consideration, but excluding any consideration which would be so and so for use of any patent in 4.
It's right. Suppose I have a patent in a drug. I give it to you. That would be your exclusive use. You will have. Can I give it to him? No, because if I give it to him, I will be violating this contract between you and me. It necessarily means an exclusive.
A platform like Facebook, it could provide the space for
others also.
So many.
Very well. So if that be so,
being the owners, they are entitled to.
You are right. Being the owner. Now suppose if I have a patent in a drug, I have an exclusive contract being a company, pharmaceutical company, to produce that particular drug. I can't have with him. Then what you are paying is a royalty. What is contemplated is this. But it is not that I'll give it to the same patent to you, to him, to everyone, and I get some money. Will that be construed as a sort of a royalty when I am giving everything to everyone?
My lord, section 9, my lord, it's a deeming provision. Income deemed to accrue or arise in India.
You say section 9, yes.
Section 9. Section 9, my lord, subclause 1.
Yes.
Then, my lord, after 3 pages, my lord, we'll get Roman 6 after 4 pages. Income by way of royalty payable by after 4 pages.
Income by way of royalty.
Payable by the government, so and so. Then, my lord, I've come to the explanation too.
For this purpose of this clause, royalty means consideration, including any lump sum consideration, but excluding any consideration which would be the income of the recipient chargeable under the head capital gains for transfer of all or any rights. That means by this agreement, If I have a patent with me, I am transferring it to you all my rights. Even I can't produce that particular drug.
All or any rights.
Depends upon what kind of an understanding you are in. Transfer of all or any rights, including the granting of license. I mean, that means it's like this. I have a patent. I have entered with you an agreement, and I am outsourcing even the grant of license by you to a third party. But ultimately, the understanding is between you and me. In respect of a patent, invention, model, design, secret formula or process or trademark or similar property. Imparting of any information concerning the working, the use of patent, imparting.
Use of
5. You see 5. Transfer of all or any rights, including granting of a license, in respect of any copyright, literary, artistic, scientific work, including films, videotapes, for use in connection with the television tapes, with radio.
Then 5,
broadcasting.
rendering any services.
Yeah. Explanation: for the purpose of this clause, computer software means any computer program recorded on any disk, tape, perforated media or other information storage device, includes any such program or any customized electronic data. For removal of doubts, it's hereby clarified that the transfer of all or any rights in respect of the property or information only included transfer of all or any rights. Doubts. Now tell us one thing.
Please.
They permitting you to, or the permitting the SSC to advertise itself on that software. It's a sort of a software only, the Facebook. Would that mean that an exclusive right has been granted to the SSC by the Facebook, that henceforth you will have exclusive right for advertisement, and you can also outsource the advertising to third parties? It is not such an understanding?
No.
But that's not the case. And even before the tribunal, those clauses have been extracted also.
See, at least subject to what you say, we don't say so. Subject, at least our understanding is this, that it is only to use that space for advertising. The principal is not precluded to give that space to further third parties to advertise them. So it's not an exclusive use given to the SSC to use the space for its advertisement. And the SSC is not given exclusive right by the Facebook to outsource the advertising to a further third parties and earn money. That is also not the case.
In a case where exclusive
Page
rights
85
are
they
given.
extracted the clause which says non-transferable, non-exclusive.
Non-transferable, everything. These are the clauses which will come in.
Exclusive use would mean purchasing that right, which would get covered under engineering analysis.
Exclusive use means you getting that right.
I am buying that right.
You are further given a right to sell it to third party as well. But it is not such an understanding.
That's why, my lord, my humble submission is it's not covered under engineering analysis. Engineering analysis, the four type of cases examined by the Honorable Apex Court deals with what my lordship is saying.
But tell us one thing, then will it be construed as a royalty? It will not be construed as a royalty. See, simple, at least in a layman, simple is this. I wrote a book, I give it to publisher, the publisher has the exclusive right to sell it. He will give me a royalty. With all the rights attached to that copyright of the book is exclusively with the publisher. He will do it, whatever he wants. So what I am getting is a royalty. Possibly in that eventuality, he has to deduct TDS and then pay me.
In fact, the SSC itself, when they make payments to Microsoft in the same assessment.
Milord,
rates,
engineering
where I
analysis.
get a license, I have been deducting tax at source and paying. And
You bought the license in that case?
in not one of these three pays,
I know.
another payee. So wherever there is a transfer, there is a payment of
It's
royalty.
an exclusive right to you.
Milord,
Yes, for the certain other software which is there, and
May
that they've
clarify
accepted.
May I just clarify you? What was decided by the Honorable Apex Court is, Milord. In our answer to the question posed before us is that the amounts paid by the resident Indian end users, distributors to non-resident computer software manufacturer suppliers as consideration for resale use of the computer software, though under agreements, is not the payment of royalty for the use of copyright. Where they purchase, my lord, it's not the use, it's not the copyright.
That's right.
It's not royalty.
That's right.
Here, my lord, they are not buying it. That's why it is royalty. May I just clarify, my lord?
They are not buying it?
Here, my lord, they are in the given case, the present case, they are using the space or the services rendered by the foreign entity. That's why it is royalty. If they buy it, my lord, outright purchase, then it would not amount to royalty. That is what the Apex Code says. In a case where there is outright purchase, the Honorable Apex Court says these payments do not get covered under Section 9 deemed provisions, and they cannot be treated as royalty because you are buying it. Where the services are used or acquired or not acquired, used, or where, my lord, there is an agreement by the foreign entity permitting the use of a space or use of a service, use of a technology, then it would get covered under Section 9.
But tell that, is that use only confined to this SSC? Or others also similarly placed can also put their advertisement? They can do it?
They can do it.
Then to that extent, what? Then the SSC doesn't have the exclusive use then?
No.
Are you saying to the extent the space has been given, he has the exclusive use?
To the
Hence
extent
the
of
royalty.
payment, to the extent of payment made by the SSC in India for the use of, for availing services.
But much would depend upon in what manner the rights are getting transferred insofar as that space is concerned. Okay. Now, if
there is a case or a finding by the tribunal that something has been purchased by the Indian SSC, Indian entity, from the entity situated abroad, then it would get covered under engineering analysis.
that we got it, that's what you want. But here there is no purchase.
If not, my lord, revenue will be out of the.
No, you say there is no purchase here.
That's a simple case.
Then what is the transaction then? Transaction is usage of space for
Yes,
advertisement.
Please.
Okay, let's see in what manner. Let's see the contentions also in this order. See para 9.
Please.
The CIT also held payments made for use of software is royalty under the provisions of the income tax also. In this regard, he says this. The decision of the Karnataka High Court in the case Samsung Supra is applicable in the facts of this case. Accordingly, the claim that use of software is not royalty is rejected. Is it not akin to a cloud space hiring?
For one of
It
them,
is, my lord.
so the three P's, one is Facebook for advertising. One is what is called rocket science, which is MailChimp for bulk emails again for advertising. Third is for Amazon for cloud space, as my lord correctly pointed out. So these are the three.
So in cloud space also, like, in normal, this thing, we put our photograph, we just
Google,
upload it.
Yes.
It's also using the space only. Will that be construed as a royalty?
Because ultimately, my lord, an advertisement, the use of that space is done in such a way, my lord, the SSC would reach a larger number of customers. Space is used in a way of advertisement only. So use of any my lord, it would come under section 9, explanation 2. My lord, cloud spacing, my lord, the discussion.
May I just add one point at this?
My lord,
point?
how does cloud computing work? There is a, my lord, discussion by the AO in page number 28. What is cloud computing and what is cloud computing work? Page 27 and 28, Inc.
He seems to have done a lot of work on the, yes,
My lord,
18. You said 28.
27. Cloud computing basics. Whether you are running applications that share photo to millions of mobile users or you are supporting the critical operations of your business, a cloud service platform provides rapid access to flexible and low-cost IT resources. With cloud computing, you don't need to make large upfront investments in hardware and spend a lot of time on the heavy lifting of managing that hardware. Instead, you can provision exactly the right type and size of computing resource you need to power your newest bright idea or operate your IT department. You can assess as many resources as you need almost instantly and only pay for what you use. Cloud computing provides a simple way to assess servers, storage, database, and a broad set of application services over the internet. A cloud service platform such as Amazon Web Services owns and maintains the network connected hardware required for these application services, while you provision and use what you need via web application. The AWS provides a broad set of cloud-based products, including compute, storage, database, networking, mobile developer tools, management tools, security, and enterprise applications. The cloud computing is an arrangement in which the cloud provider hosts the shared computing resources such as hardware, software applications, etc., and the cloud user assesses them for storage, data processing, etc., via internet on a need basis. Cloud computing enables enterprises to adjust resources quickly to meet the fluctuating and unpredictable business demands. The payments made by the SSC company are made for various facilities provided by AWS, which are predominantly in the nature of online data storage and retrieval, database processing facilities, usage of third-party open space software, seamless data integration, transfer and support for processing queued data. The SSC company submits that unless the service provider makes available his technical knowledge, experience, skill, know-how, or process to the recipient of the technical service in view of DTEAA, the liability to tax is not attractive. The contention as above is not acceptable for the following reasons. There will be sites of the SSC company wherein the data connectivity and networking is provided by the AWS. Generally, every site has a router being placed in the premises for the data communication purpose. It is clear that the service provided by AWS also includes providing the routers and data connectivity and networking. The SSC company, by relying the decisions of the tribunal, is wrong in claiming that there is no involvement of any human intervention at any stage and that the entire process is fully automatic technique. Had such been the case, there would not have been any separate mention for the provider to ensure that the facility is adequately staffed for the provision of all services and that the provider employees, agents, and subcontractors have sufficient skill, expertise, and ability to perform their duties in a competent and professional manner. This shows that the SSC is in fact not only aware of the technical expertise required in obtaining data hosting services, but also appreciative of the quality of manpower to be employed for such technical services. Now the contention of the SSC company with respect to taxability as royalty is examined. May I continue?
Read it, read it.
In order to examine the claims of the SSC company, it is pertinent to have a look at the meaning of royalty in the Income Tax Act 1961. Subsection 1(6) of the Income Tax Act, the term royalty has been defined under explanation 2 to mean consideration, including lump sum consideration, but excluding any consideration which would be the income of the recipient chargeable under the capital gains for 1. The transfer of all or any rights, including the granting of a license in respect of a patent, invention, model, design.
Tell us one thing, the Facebook has copyright in what? The Facebook has copyright in what? It would be the complete, the software which they are playing as a Facebook.
Yes, the platform which it creates, which enables users to not only place advertisements like the respondent here, but also other users to come and access these platforms. It's essentially a platform which it is designed. It has the copyright in that.
In the platform itself?
Yes, in the design, the use of that platform.
Yes.
How it has come up with that, how it is conceived.
Now, whether the platform Facebook per se is for the exclusive use of the SSC?
No.
If not, see now read this, the clause. Royalty has been defined and explained to mean consideration, including lump sum consideration, but excluding this. Transfer of all rights, including granting of a license. Here it is a case of patent.
Transfer of all or any rights. So if they have a part of the rights also can be given. Transfer of all or any right means it is not all rights.
Very good. Taken. Or lesser rights.
Lesser rights.
Which includes granting of a license in respect of a patent, invention, model, design, secret formula, process or trademark or similar property.
The AO has not invoked clause 1, madam. I'm sorry to interrupt. Clause 3 and clause 4A is what he has sought to.
The use of any patent, invention, design, secret formula, process or trademark or similar property.
4A. The use or right to use any industrial, commercial or scientific equipment, but not including the amounts referred to in 44BB. Those are the two clauses or subclauses under which he seeks to.
3 and 4A.
Please, madam. But more crucially, what is yet to be in the next paragraph is that this is overridden by the provisions of the double tax avoidance agreement. Now, India has entered into DTAAs with USA and Ireland, which is the two countries in which Facebook and Amazon are resident in. So in case of a conflict between a domestic law and clauses of a DTAA, the Supreme Court in Azadi Bacha, which has been thereafter followed, is that whichever is more beneficial to the SSC has to be looked at. So the Supreme Court in engineering analysis and the tribunal, most significantly in my case, has in fact interpreted or examined the agreements in the light of the definition of royalty under the DTAA, and has held that since these payments don't amount to royalty under the applicable DTAAs, it would not be royalty under the DTAA.
So, are you saying that we should not see the?
I would only urge that it may not be necessary because the tribunal and Supreme Court say, since it is not royalty under DTAA, the question of going into the act itself does not arise. That is in fact the finding also of the tribunal.
It's a royalty.
Not royalty under the DTAA.
Oh.
You cannot be put in a worse off situation under the act.
So you can't read the provisions of the IT Act.
Yes, that is what the tribunal also holds. That is what the Supreme Court in engineering analysis also looks at.
Now, in this case also it holds the same thing?
Yes, my lords. I may just take
then
my
why
lord.
is he referring to these provisions of Income Tax
The
Act?
assessing officer, in fact, my lords, on that same page, just below the definition of 916 explanation 2, he says, look at Article 12(3).
Yeah, DTA.
But crucially, perhaps, my lords, at the time of analysis, it is only analyzed with respect to the provisions of the Act.
IT Act.
The assessing officer. The tribunal, my lords, I'll just take my lords for a moment to that.
What is the difference between the
Yes.
definition of royalty under the DTA and the income tax? Act?
Precisely. So in fact, my lords will see explanation 2, clause 5 of the section 916. It says transfer of any right in respect of. I just take that.
Any copyright literally?
In respect of. My lords can see that the crucial portion is in respect of. That, if my lords have in the article of the DTAA, it is transfer of any right for the use. So the Supreme Court has held that since the DTAA contemplates a payment becoming royalty only if there is transfer of a right for the use of a software, only then would it be a payment of royalty. The Act makes it much wider. If you transfer any right in respect of the copyright, if you transfer any right in respect of the copyright, it could give rise to royalty.
Will that not be for the use of copyright?
My payment?
Yes.
It is not the right to use the copyright. There's a distinction between the right to use a copyright and the right to use a copyrighted article. As my lords correctly pointed out, the case of a book, an author writes the book. He gives a copyright to a publisher to publish X number of books. Now, if I were to go to a bookstore and buy that book, I don't get the copyright of the author. I only get a limited right to read the copyrighted article. That is the distinction. The publisher gets the use of the copyright in the writing itself. I only get a right to read the copyrighted article. There is a distinction.
So you are saying this is usage of a copyrighted?
Precisely, that is my lord's words fell out of my mouth. That is, I get the right to use a copyrighted article, which is Facebook's platform. They don't give me a right to then use the source code. In technology, it's called
Not only you, others also get
nobody
that
else. In fact, that's why the clauses also have been interpreted by the tribunal to say that I get a non-exclusive, limited, non-transferable license to place certain ads for a limited purpose and for limited time also. It is not also an endless, it is a license to use for a limited time. In that time, I pay a certain amount, I get to use a copyrighted platform. Similarly with Amazon, if I don't make a payment in 2025, my access to the cloud would go into just, for instance, 31st December 2024. If I were to move, like my lords pointed to Google phone, if I were to use from that to just say an Apple phone, all my photos on Google Photos may go. It's only by paying this monthly subscription every month, some amount may go to Google or to Apple as the case may be. Do I get the limited right to use the copyrighted platform of saving my photos or other documents? That is all I get. I get a very limited use of the copyrighted article. There is a distinction to be drawn between use of the copyrighted article and use or rights in the copyright itself.
Let's see the conclusion drawn by the ITAT.
Please.
Let's read that. And I hope, Mr. Raviraj, what is being argued is on the basis of the interplay between the Income Tax Act and the DTA. So you agree that between the two, which is more beneficial to SSC, will have a play. So let's assume, are we proceeding on that premise? It would be DTAA which need to be seen it, not the provisions of the Income Tax Act. If that be so, then let's concentrate only on the DTA provisions and the interpretation thereof. That's all. Okay, let's see that.
Page
Let's see.
83.
Page
83, Inc. 83.
So let's proceed on that. Let's not go into the IT Act then.
Para 12.
Mm-hmm.
May I? 83, para 12.
Mm-hmm.
After analyzing the provisions of Income Tax Act, provisions of DTAA, the relevant agreements entered into by the SSC with non-resident software suppliers, provisions of the Copyright Tax, and the circular issued by the CBDT, various case laws relied upon by the parties, the Honorable Supreme Court concluded as under. Given the definition of royalties contained in Article 12 of DTAA, mentioned in paragraph 41 of this judgment, it is clear that there is no obligation on the persons mentioned in Section 195 of the Income Tax Act to deduct tax at source, as the distribution agreements, EULAs, in the facts of the case do not create any interest or right in such distributors or end users, which would amount to the use of right to use any copyright.
That's right. So that's what is being said. What is being used is a copyrighted material. That's all. He is not, like what example he has given, what you are buying a book, there is a copyright in favor of the publisher. But what you are doing is something which is copyrighted and I am using it. I am reading it rather, reading it. The
provisions contained in the Income Tax Act 916, along with explanation 2 and 4 thereof, which deal with royalty, not being more beneficial to the SSC, have no application in the facts of the case. The provisions contained in Income Tax Act 916, along with explanation 2 and 4 thereof, which deal with royalty, not being more beneficial to the SSC, have no application in the facts of the case. Our answer to the question posed before us is that the amounts paid by resident Indian end user distributor to non-resident computer software manufacturers as consideration for the resale use of the computer software through EULA's distribution agreements is not the payment of royalty for the use of copyright in the computer software, and that the same does not give rise to any income taxable in India, as a result of which persons referred to in section 195 of the Income Tax Act were not liable to deduct any TDS under section 195 of the Income Tax Act. The answer to this question will apply to all 4 categories of cases enumerated in para 4 of the judgment.
Okay.
Next para, Maharaj.
Next para.
Hence, the relevant DTAA provisions should be considered in the cases before us also for determining the question whether the payments made by the SSC to the above 3 non-resident companies are in the nature of royalty or not. Hence, there is no necessity to refer to the provisions of section 916 of the Act for the payments made to the non-residents referred above. The term royalty defined as under clause 12, article 1203 of the India-USA DTAA, the term royalties as used in this article means payments of any kind received as a consideration for the use of or the right to use any copyright of a literary, artistic or scientific work, including cinematography films or work on film, tape or other means of reproduction for use in connection with the radio or television broadcasting, any payment, trademark, design or model, plan, secret formula or process, or for information concerning industrial, commercial or scientific experience, including gains derived from alienation of any such right.
See, you look in it from a different perspective. There is a software where you are putting advertisement, he is putting advertisement, I am putting advertisement, my lord is putting advertisement. Who will have a copyright in that software?
Person owning it.
That's right. So we are using the copyrighted material, nothing more. See, the impression one gets is you are using, this is a copyright. Once you are putting an advertisement, you are actually using it, and money which you are paying is a royalty, something like that, what is being said. But the intent is you have to understand in a normal parlance, how are you using it? What are you doing it? You are only putting an advertisement. They are giving the space. I am putting my advertisement. They are giving space to you. You are putting your advertisement similarly. The ultimate outer shell is the copyrighted. What we are putting is the space within that, the shell.
Note B.
Yes.
Payment of any kind received as consideration for the use of or right to use any industrial, commercial or scientific equipment other than payments derived by an enterprise described in para 1 of Article 8, shipping and transport from activities described in 2C or 2 or 3 of Article 8.
Will this be applicable here?
2C would not, I mean, for Article 12(3)(a) would apply, not 12(3)(b).
No,
Payment of any kind received as consideration for the use of or the right to use any industrial, commercial or scientific equipment, comma, other than payments received by an enterprise, so and so.
Will it be construed as an equipment? industrial, commercial, scientific equipment other than payments derived by an enterprise described in one from activity described in paragraph 2C or 3 of Article 8. Let's see those. Are those activities are those the activities other than the payments derived?
No, in fact, that's been analyzed in just the next page.
Very well, let's see that.
Paragraph 15. May I
We
read?
shall now advert to agreements entered into by the SSC with the three non-resident companies mentioned above in order to understand the nature of services rendered by these companies and also to understand whether the payments made to the three non-resident companies are royalties or not in terms of the provisions of DTAA. The relevant clauses are extracted below. Facebook, license grant, 4.1, in consideration of your compliance with this
Okay,
agreement.
I think let's see paragraph 16.
A careful perusal of the relevant provisions of the agreements entered into by the SSC with Facebook, Rocket Science Group would show that both these non-resident companies are allowing the SSC to use the facilities provided in their sites, which includes inter-alia software facilities also. The purpose of compelling the SSC to use those facilities, as could be inferred by us, is to create an environment of ease in creating the advertisement content to suit the platforms of Facebook or MailChimp. The environment of ease is beneficial and time saving to both advertiser and the advertising platform. Thus, the facilities have been created by the non-resident companies for mutual benefit. However, a person shall get the right to use those facilities only when he enters into an agreement with them for hosting his advertisement or for sending bulk mails, meaning thereby the use of facilities is intertwined with the activity placing the advertisement in web portal of Facebook or sending bulk mails. In case of web hosting charges paid to AWS, the SSC is allowed to use the information technology infrastructure facilities. We shall now refer to the decisions relied upon by the learned AR before us. Calcutta bench in so-and-so has considered an issue whether the payment made to foreign search engine portals for online advertising services resulted in accrual of income in India in their hands in terms of 9(1) of the Act. The coordinate bench referred to the following decisions rendered by co-benches. In the above said two cases, tribunal held that the amount paid by the SSC to Messrs. Google Ireland Limited for the services rendered for uploading and display of the banner advertisement on its portal was in the nature of business profit on which no tax is deductible at source, since the same was not chargeable to tax in India in the absence of PE of Google Ireland India in India. Finally, the coordinate bench held as under in case of right Flores. In view of the above discussions, we are of the considered view on the limited facts of the case as produced before us. The receipts in respect of online advertising on Google and Yahoo cannot be brought to tax in India under the provisions of Income Tax Act and also the provisions of US and Ireland tax treaty. This observation is subject to the rider that so far as the PE issue is concerned, we have examined the existence of PE on the basis of website simpliciter and no other additional basis, as no case was made out for the same. In any case, revenue has not brought anything on record, either at assessment stage or even before us, to suggest that Google or Yahoo had a PE in India, and as held by a special bench of this tribunal in the case of Motorola, DTAA is only alternative tax regime and not an exemption regime, and therefore the burden is first on the revenue to show that the SSC has a taxable income under the DTAA, and then the burden is on the SSC to show that its income is exempt under DTAA. No such burden is discharged by the revenue. Accordingly, there is no material before us to come to the conclusion that Google or Yahoo had a PE in India, which in turn could constitute the basis of their taxable liability. The taxability of web hosting charges paid to Amazon Web in its hands was examined by Pune bench of tribunal in the case of EPRSS Prepaid Recharge Services India Private Limited, which was relied upon by the learned ear. The relevant discussions made and decision taken by Pune tribunal are extracted below. We have heard the rival contentions and perused the record. The issue which arises in the present appeal is in respect of charges paid by the SSC to AWS. The SSC was engaged in sale of recharge pens and did not have the facility available with it of high technology equipments, that is servers. In order to carry on its activity of distributorship of recharge pens, it used servers of Amazon, for which it paid web hosting charges. Before using the services available of Amazon online, it entered into an agreement under which fee structure was provided. Copy of the agreement is placed in so and so. Agreement called AWS Customer Agreement, which contains the terms and conditions that govern SSC's SS to and use the service charges. It was agreement between Amazon Web Services Inc. and you, that is SSC. It is provided that agreement takes effect when you click an I accept button. Clause 11 lays down that you may assess and use the service offerings in accordance with agreement. In clause 1.2, it is provided that to assess service, you must create an AWS account associated with valid email address. Clause 1.3 provides that if you would like to support the services other than the service we generally provide to other users of the service without charge, then you can enroll for customer support in accordance with the terms of AWS support guidelines. Clause 2.1 lays down that Amazon could change, discontinue, or deprecate any of the service offerings or change or remove features or functionality of the service offerings from time to time. As per clause 4.1, you are solely responsible for the development, content, operation and maintenance and use of your content. Now coming to clause 5.5, which provides the service fees to be paid. Agreement provided that Amazon would calculate and bill the fees and charge monthly. It is further agreed that you have to pay applicable charges for use of service offerings as described on AWS site using one of the payment modes they support. We may refer to clause 8.4, which lays down the service offerings license, under which it is provided that Amazon or its affiliates or licensors own and reserve all the right, title, interest, and the service offerings. However, limited, revocable, non-exclusive, non-sublicensable, non-transferable license is granted to you to do the following term: assess and use the service solely in accordance with this agreement, copy and use the AWS content solely in connection with your permitted use of services. It is further provided that
the ingredients or the parameters by which you actually come to a conclusion.
Lord, the last sentence may be seen. Lord.
Yes.
Last sentence of the
Read it.
paragraph. However, page 92. However, limited, revocable, non-exclusive, non-sublicensable, non-sublicensable, non-transferable license is granted to you to do the following.
Access and use the service solely in accordance with this agreement. And
no, my
copy and
emphasis,
use
Lord,
the
my emphasis is on a limited use of license is given.
From whom? By whom?
My Lord, non-transferable license is granted to you.
Yes.
SSC to do the following in term.
But if
So a license, limited license is given.
Right. But if a person has a copyright, let's assume that's your case also, then he should have the exclusive use. How can you limit? You can't limit it. And read 2. Copy and use the AWS content solely in connection with your permitted use of the service. If anything which is not permitted use of services, you can't. What is this kind of a right which is getting transferred? Though I have a copyright, but I will be doing this, not the other things, limiting it. Will that be construed as a transfer of a copyright? See, for royalty, you have to see that. Let's see, read further.
It is provided that no further, no, so it is further provided that no rights under this agreement are obtained by you from Amazon or its licensor to the service offerings, including any related intellectual property rights. The term between the parties are defined as per 14, and terms which are relatable to the issue raised are as under. AWS content means content we or any of its affiliates make available in connection with the services or on the AWS site to allow access to and use of the services, including WSDLs, documentation, sample code, software libraries, command line tools, and other related technology. AWS content does not include the services. AWS marks means any trademark, service marks, serviceable or trade names, logos, and other designations or AWS and its affiliates that we may make available to you in connection with this agreement. The SSC has used the services and has made monthly payments to Amazon. The SSC has attached sample invoice Amazon at page 23 to 41 of the paper book and ledger extracts of Amazon in its books at page 1 and 2 of the paper book. The SSC had filed submissions before the assessing officer giving detailed on web hosting charges, which is as under. Web hosting charges. Primarily, EPRSS requires servers to run the various online resources. Due to this, there is a very high requirement of servers, since purchase, maintenance of servers, and its upkeep required skilled manpower. BPRS does not have the same. Hence, servers are taken on hire from Amazon in its cloud units. Ledger copies extract of web agreement is also attached.
I think let's come to page 97.
Yes.
Last paragraph.
The above said decision clarifies the point that mere usage of a facility does not give rise to provision of any technical service. The same analogy, mere usage of facility provided by the above said non-residents does not render the payments as royalty payments, since the core point of parking any copyright attached to the said facilities do not arise.
Now read the next para.
In the case of engineering analysis, the issue related to issue of license to use the software, that is software purchased by a person, shall be used by a buyer for his own business. Since the license was granted without parking any copyrights attached to the software, the Honorable Supreme Court said the payments received by the non-resident software companies cannot be taxed as royalty under the provisions of DTAA, and hence there is no requirement to deduct tax from the payment made to them by the resident SSC. In the instant case, the recipients, that is Mrs. Facebook and Rocket Science Group, only allow the SSC to use their facilities for the purpose of creating advertisement content. Payment made to Amazon Web Service is only for using the information technology facility provided by it. That too, the billing would depend upon the extent of usage of those facilities. In fact, these non-resident companies do not give any specific license or right to any of the facilities which include software, and these facilities are not going to be used for the use of the business of the SSC. Right to use those facilities, as stated earlier, is intertwined with the main objective of placing advertisements in the case of Facebook and MailChimp.
So that's the limited right, putting advertisement.
Yes.
We'll continue after lunch.
Serial number 37.
Yes.
Here for respondent number 1, we have engaged senior counsel, Mr. Gurumat. He is in funeral, my lords. He won't be able to come today. So it may be listed day after tomorrow.
No, we'll see. Let's see after lunch. We can come. Definitely we'll hear it.
Good.
Yes.
Kind indulgence, my lord. My lord, sorry, my lord, I'm troubles, my lords. My lords has directed me to file necessary application for releasing of cargo, then move, then my lord, I have served the copy also to my learned friend. I requested my learned friend to instruct your client to release the cargo. My lord, I have given on 16th. Now, till today, they have not released. Therefore, I request my lord.
File that application.
I have filed the application.
You got a copy?
Yes, please.
When do you want that application to be listed?
My lord, tomorrow or day after tomorrow, my lord. If my lord's convenient, my lord, because I am not troubling my lords, because it's separate bench, my lord. Tomorrow at 4 o'clock, my lord, it should be, my lord.
Can we have it on Monday?
My lord, because my lord, client is suffering, my lord, from past 15-20 days.
When was the last mentioning you made?
My lord.
When did you mention the matter last?
My lord, last Wednesday, my lord.
I will have it on 24th. 24th. That's Thursday.
Thursday.
Okay.
Thursday.
I inform the other councils.
My lord, I have served the copy to Mr. M.N. Kumar also, my lord.
Although this is his role.
My lord,
concerns him only. But you inform Mr. Kumar also.
Oh, I have informed my lord. I requested also my lord to, I am going to move the matter. I requested, he agreed, my lord. Any date, my lord's convenient.
We will have it on 24th at around 4 o'clock.
Please, grateful. Great.
Just note it down and.
Please, grateful. I'm sorry, my lord, troubling my lord's at that.
This would be before that bench, no?
Please.
We will do one thing. Can we
Please.
do this?
If it is tomorrow, my lord is grateful to me.
See, we have to seek the convenience of my Lord Justice Rai also.
Please.
You do one thing.
Please.
You mention it tomorrow morning. We will take his this thing convenience also. You mention this tomorrow morning.
Please.
Okay. In the meantime, we will speak to him also.
Please.
And seek his convenience.
Please.
Okay.
Please.
Just we'll do that way. We'll do it. You would be there tomorrow morning. So that we can also have his convenience.
Please. Please.
His availability also.
Please. Please.
Thank you.
Great.
Okay, take it, man. But tell us when you have served a copy on her, you have framed that additional question. We were to give time to her to file. Just ask. They have filed it on this edition. Who is the counsel who appeared for that? But there was some advocate who was present. Just ask her whether she intends to file any add-on. Yes.
$27.
Para. Page 98, para 21.
Yes.
In the instant case, the recipients, that is Facebook and Rocket Science Group, only allow the SSC to use their facilities for the purpose of creating advertisement content. The payment made to Amazon Web Services is only for using the information technology facilities provided by it. That too, the billing would depend upon the extent of usage of these facilities. In fact, these non-resident companies do not give any specific license for the use or right to any of the facilities which include software, and those facilities are not going to be used for the use in the business of the SSC. The right to use those facilities, as stated earlier, is intertwined with the main objective of placing advertisements in the case of Facebook and MailChimp. In the case of AWS, the payment is made only for using information technology infrastructure facilities on rental basis. Hence, the question of transferring the copyright over these facilities do not arise at all. The agreements extracted above also make it clear that the copyright over those facilitating software is not shared with SSC. In any case, the main purpose of making payment is to place advertisements only and not to use the facilities provided by the non-resident companies. Thus, the facilities provided by the non-resident companies are only enabling facilities which help a person to place his advertisement contents on the platform of Facebook or to use MailChimp facility effectively. In the case of AWS, the payment is in the nature of rent payments for the use of infrastructure facilities. Accordingly, we are of the view that these non-resident companies stand on a better footing than those SSCs before the Honorable Supreme Court in the case of Engineering Analysis Center of Excellence Private Limited. Accordingly, following the ratio laid down by the Supreme Court, we hold that the payments made to the above said three non-resident companies do not fall within the meaning of royalty as defined in DTAA. The AO has not made out an alternative case that these payments are also taxable business in India. Hence, there is no necessity for us to deal with that aspect. We have noticed earlier that the learned CIT appeals has followed the decision rendered by the High Court of Karnataka in the case of Samsung Electronics. In the case of Engineering Analysis Center of Excellence, the decision rendered by the Honorable Karnataka High Court in the above said case has been overruled by the Honorable Supreme Court. Hence, on this reasoning also, decision rendered by the CIT appeals would fail. In view of the foregoing discussions, we are of the view that the payments made by the SSC to the three non-resident companies referred above cannot be considered as royalty payments, and hence they do not give rise any income chargeable in India under the Income Tax Act in all the 3 years under consideration. In that view of the matter, there is no requirement to deduct tax at source from those payments under 195 of the Act. Hence, the SSC herein cannot be considered as an SSC in default. Accordingly, we set aside the order passed by the CIT appeals for the years under consideration and direct the AO to delete the demand raised under 2011 of the Act and also the consequential interest charged under 201(1)(a) of the Act for all these years under consideration.
Now, what are your submissions? How would you demolish this case or this judgment, this order? See, what is, I think, relevance if you see.
Unless, my lord, something comes within the definition of royalty. Basically, my lord.
Huh?
Unless the revenue makes out a case that it comes within the definition of royalty.
See, royalty is something.
Because the use of any copyright it says use of any copyright. Definition of royalty.
And you mind it, all this definition of royalty talks about intellectual property rights, patents, trademark, copyright, all those rights which exist in those intellectual property.
But there is one more, my lord, apart from, my lord, whether it's right to, my lord, copyright, my lord, unless the revenue is able to prove, my lord, a copyright aspect, But my lordship's question, my lord, the intellectual property rights and all, there is one section.
Yeah, no, if you see 9, at least what we have read, at least prima facie reflects the rights flowing through through intellectual properties. And the money which is given, or the consideration which is given, that is construed as a royalty between the actual right holder in a intellectual property as against a person who has been licensed that intellectual property, and the licensee paying the licensor in a way the consideration that is construed as a royalty. It's like a book written and the rights given in the book to the publisher. It's something interplay or a relationship between those two persons which is contemplated, and the consideration thereof construed as a royalty.
But Income Tax Act, my lord, explanation 2. 3, use of any patent, invention, model, design, secret formula or process.
See, these are all intellectual property. This process is nothing but patent. They're all part of intellectual property. It is something like that, and rightly so. Royalty, it's not only this, the definition of royalty is not only good for this Income Tax Act. Even otherwise, what is royalty? Royalty which is being paid in a normal sense also, in a general parlance also, this is royalty. Not
Lord, the whole discussion has come, my lord, because of section 9, because of the deeming provision. Whole discussion has come, my lord, because of section 9.
That's right.
Which deems, lord.
Where is
Section
that?
9 is a deeming provision.
How do we get
Otherwise,
that?
this problem would not have come, my lord. Income deemed to accrue or arise in India.
Deemed to
The
have.
whole meaning of royalty would take a different meaning only because of a deeming provision. My lordship is right, my lord. Normally speaking, understood meaning of royalty is different than what is being deemed in section 9. But still, my lord, reference to DTAA will have to be made.
But reference to DTA now, that's so in any case, we would be out of Income Tax Act when it comes to DTA. Then more beneficial, and that's how even the tribunal. And it appears to be the case of the revenue also. What do you say? Then you will come back to income tax.
Income which are actually not taxable. So there are income like royalty, payments of royalty, payments of in the Vodafone case, which is there, where shares will be transferred from one non-resident to another. That will have to be taxed in India because of 911 income tax. Because the underlying value of that share, although of non-resident, goes in India. Because for any dealing fiction, it has to be strictly consumed. So even because the DTAA, it will have to be strictly considered that this payment would fall within the code square parameter of 916, with the explanation to that. On that term itself, and it is considered that it will not fall. But even apart from that, as when the two deals are protected or are the benefit of DD, both USA and Ireland, case to Ireland and the other two are USA. Then all that must be looked at is the DTA.
So you say even divorce DTA, even on the strength of Income Tax Act, it would be not a royalty.
It would not be as clear cut definitely as a DTA.
Then, my lord, section 7 may come, my lord, subsection, because what I read was explanation 2 to 6. 7, my lord, actually there, my lord, royalty is defined. Explanation defines what royalty is for the purpose of section 9. Subsection 7, my lord, income by way of fees for technical services is defined. My lord, dealt with. Income by way of fees for technical services payable by so and so. Explanation 2. For the purpose of this clause, fees for technical services means any consideration, including any lump sum
But will
consideration.
this be construed as a technical service?
No, I'm saying, my lord, section 9, my lord, how the payments are being dealt, not in,
But why should we go into all this? Now DTA, now let's proceed on that. Yes, now what do you have to say?
For the minimum server, multiple different laws itself, which is, that also is covered by the DA, but I may not get there, because it's not processing officers based in all the minimum servers. So you refer to the DTA, that is extracted in engineering analysis, but I also got copies of the. Based on a OECD model, and then most of the DTAs enter into across the country, but almost everything. OECD is an organization of economic cooperation. So by referring to one PCA, standard is for other countries, I just produced one with USA. But the time is Article 12.
This is between India and USA.
12, 8, 7, they will be the bottom big, small.
Hmm.
The royalties and fees for included services. I just need to short out. Royalties and fees for included services arising in a contracting state and paid to a resident of another contracting state may be taxed in that other state. It will be taxed in Ireland or US. It depends. However, such royalties and fees for included services may also be taxed in the contracting state in which they arise and according to the laws of that state. But if the beneficial owner of the royalties or fees for included services is a resident of the other contracting state, the tax or charge shall not exceed, and the way of making sure that the same income is not taxed twice. That may not be the only reason I'm not reading. Clause 3 is surplus. The term royalties, as used in this article, means payments of any kind received as a consideration for the use of or the right to use any copyright of a literary, artistic, or scientific work, including cinematographic films or works on films, tapes, or other means of reproduction for use in connection with radio and television broadcasting, any patent, trademark, design, or model, plan, secret formula, or process, or for information concerning industrial, commercial, or fields, including gains derived from alienation of any such right or property, which are contingent on the productivity, use, or distribution thereof. And B, payments of any kind received as consideration for the use of or the right to use in industrial, commercial, or scientific activity, other than payments derived by an enterprise described in paragraph 1 of Article 8 from activity described in paragraph 2C or 3 of Article 8. So, once again, it says that payment should be made as a consideration for the use of any copyright. As a pointer, there is a distinction between me using a copyrighted article and me using the copyright in the copyright in
The copyright itself, the intellectual property
itself by either reproducing, by selling, by making copies, and then using it. Then yes, no doubt that what I would be getting is a right of the copyright of the article itself. Therefore, the payment made by me to get that right would partake the character of article, no doubt. But if I simply get the right to use a copyrighted article for a limited purpose, which is expressly non-transferable, non-exclusive, for a limited purpose of a limited time.
for advertisement.
For advertisement only, and if I infringe upon any of the agreements or the terms in that agreement, the agreement also provided for a sanction if I do not adhere to the terms. Then all I'm getting is a limited right in the copyright. Income, the payments which are made do not tantamount to royalty. Therefore, I am not required to deduct tax and make such payments. It would, if those fees had permanent establishment or fees in India, then what I would be paying to them would be their business income, which under chapter 4 of the Income Tax Act would be taxable in India, no doubt. But it is nobody's case that would, because cases are like Amazon or Facebook, have permanent establishments in India. So it is not legalized to do this income. And since I do not fall within the Article 12(3) of the DPW, what I also pay is not royalty, therefore I am not obliged to that. The private is one last one. I don't know. Understands that the CIT is relied on dishonorable court's order and sanction. Noted that fact, but then independently, Indian development has gone into every single agreement, every agreement which I looked at. Examine the scope of the right being granted to me, the limited grant which is being given to me. And it independently found that these payments not legalized or not tantamount to that. They then also note that since the CIT is relied on sanction, which is then being overruled by engineering enhancement. On that ground, also, the appeal got here.
Come again, what did you say?
The title even default engineering enhancement. And independently examined the agreements entered into by me with the days, has looked at the rights being granted to me, and has looked at the examined the Article 12(3) also the DPW, and has held categorically that these payments are merely for use of a facility for the limited purpose. And I learned to use that facility only for that purpose. I am not making a payment of royalty under the article itself. As a second or almost thereafter, they say, we also know that the CIT has relied on Samsung, which has been reversed for the Honorable Supreme Court.
What does Samsung, Supreme Court say in Samsung?
Samsung published on what has happened. Samsung, Samsung and another thing was depending over the where the question was, if a resident were to pay a non-resident an amount for use of a copyrighted article, and say copyrighted article, would that payment made wouldn't be tantamount to royalty under the DPWA or 916 of the Act. Originally, this Honorable Court held that all payments to a non-resident, you have to deduct the assets once. That the order gave rise to a lot of consequences, because if I were to, even if I were to be paying to somebody abroad, I would be obliged to deduct assets. So both the revenue and this carry the matter nothing to the Supreme Court. The Supreme Court said that may not be right. The payer is obliged to deduct tax only if the payment gives rise to income in the hand of the payee, and sent the matter back to this Honorable Court for reconsideration. Upon remand, this Honorable Court held that the payments made by, for instance, Samsung India, Samsung Korea, or other companies which are in the country, when they pay to obtain a license in a copyright article, that payment is a royalty. Therefore, they should have deducted tax and cess. So the SSC agreed with that, carried the matter in appeal to the Honorable Supreme Court. The Delhi High Court, the Bombay High Court, and even Madras High Court had held contrary, saying that such payments, similar services, do not give rise to royalty. Therefore, SSC are not obliged to deduct taxes. So there, the revenue carried the matter in appeal to the Supreme Court. All the matters were heard together. And engineering analysis, I was they heard the entire matter. Specifically, they reversed all the judgments of this Honorable Court, which held in favor of the revenue, and affirmed the decisions of the Honorable Delhi High Court and other High Court, which are held in favor of the SSC. So, in the light of the Supreme Court having it,
What was held by the Delhi High Court?
if I pay a non-resident for a limited use of a copyrighted article, then I do not get copyright is not income under income tax. So they examined the definition of copyright under the copyright, looked at the rights and liabilities of income, and held that what is being paid, what is being obtained by the payer is not a copyright as understood under the Copyright Act, and therefore it is not a payment of royalty, and therefore they should not, they are not obliged to that tax. Or those decisions of royalty ultimately were affirmed. Even the Supreme Court.
You have the judgment.
I will just place that also. I just engineering analysis record the Delhi High Court point out. Before that, one more, 4.1. Three. Para three months. Just read this one. Page number three, para three. Para two also. Appeals in these cases are by both the assessors as well as the Department of Revenue. Initial. Whereas the assessors are succeeding the question that was posed before the High Court of Delhi. The revenue has succeeded insofar as the same question was posed before the High Court of Karnataka. And in the ruling by the authority for advanced payments, including same number sources. Then para three got it, how all the matters. Para four also this, say the political, the appeals before us may be grouped into four categories. The first category, dealing with cases in which computer software is purchased directly by an individual, resident in India, from a foreign non-resident supplier or manufacturer. Can stress on the word purchase to say that only if I purchase the software would I fall within this first category of cases. A purchase should not ordinarily be understood to mean if I were to go to a shop and buy something. When I get a copyrighted article, it is a license. It's a license. I am not, if I were to even Google, I am not actually going and physically buying something. I am purchasing a license but making a monthly payment to Google to keep my photos on the cloud. That is also a purchase. Even in this case, the respondent, I make a payment to Facebook, I make a payment to MailChimp, I make a payment to Amazon to purchase a software. The platform is ultimately a software. Software is a very wide genus covering all almost intangible. So I am purchasing a software. I am an end user because I am not using the platform. I am not dealing with third party. I am not separating it. So I am an end user. I am resident in India, and I am making the payment to non-residents, which therefore satisfy all three preconditions. The first category is rented by the principal also. So, when I start to plan this, and Supreme Court cases not, which should not include. For I would anticipate, I would very fall within the first category itself. Software is not simpliciter. I buy CD in those cases, nothing like that. Here, I get a license, I make that payment. It is a software, and I am a resident user. So, you want to point that out also. So, then page 87, paragraph 87, internal page 49. That actually starts with the authority, very paragraph 87.
Samsung is discussed in 1 or 2.
Question of law posed before us in legal case has been answered in several ways, some by the way, some by the High Court of Karnataka, and some by the High Court of Delhi. These authorities will now be dealt with sequentially. The first is the authority for advanced payments, which is a body constituted under the Inter-alia Act. And the name suggests it's an advanced payment authority. I mean, if you read that,
Samsung will not do.
then para 111 at internal 16. TVs are judgment by the High Court of Delhi are dealt with the same question that now lies before them. In VIT was Ericsson, which happens to be included in civil appeal number so before. The SSC was a company incorporated in Sweden, which entered into an agreement with Indian cellular operator, pursuant to which the SSC supplied various equipment, that is hardware, embedded with software to the said cellular operator. The High Court in this case found. Once we proceed on the basis of the aforesaid factual condition, it is difficult to hold that payment made to SSC was in the nature of royalty, either under either under the income tax act or the VTA. We have to keep in mind what was sold by the SC to the Indian customers was the GSM, which consisted both of the hardware as well as the software. GSM is a kind of phone. Therefore, the tribunal is right in holding that it was not permissible for the revenue to assess the same activity in the hardware. The software that was loaded on the hardware did not have any independent basis. The software supply is an integral part of the GSM mobile telephone system. It is used by the cellular operator for providing the cellular service to the customer. There could not be any independent use of that software. The software is embodied in the system the revenue accepts. It could not be used independently. This software really facilitates the function of the system with an integral part of it. On these facts, it is useful to refer to the definition of TCS. There is the apex code that says that software is incorporated on a media will be goods and therefore liable to sales. Following discussion, this graph is required to be. Relied on the court was concerned with interpretation of uniform syllable. Para 112 of the public. This judgment was followed in VIT versus Nokia Networks over. In the High Court of Delhi, adverting this time to the further expanded definition of royalty that is contained in the retrospective amendment and inserted definition for the 1996 of the Income Tax Act. In this case, the High Court was concerned with the agreement between the Republic of India and the Republic of India for the avoidance of double taxation, the prevention of fiscal evasion with respect to tax revenue. After setting out the rationale for the clarification amendment made by the finance, the High Court said he thus submitted that the question of copyrighted article or actual copyright does not arise in the context of software, both in the DPWA and in the Income Tax Act. The right to use simpliciter of the software program itself is a part of the copyright that the software is whether or not a further right to make such copy to the customer. The decision of the Delhi Bench of Arbitration was dealt with this aspect, which definitely raised snacks towards pointing out that even software bought off the shelf does not constitute a copyright article. It has got to be clear that a special way of arbitration. However, the other argument, this is a vital point. The system is absolutely be governed by the treaty. The language of the section refers to the amended section 90 Act. It is categorically in CA versus Siemens. That the amendments cannot be read into the treaty. Under the wording of the treaty, they have already held in the that a copyrighted article does not fall within the purview of royalty. Therefore, we decide to under 1 and 2, we give it against the revenue. In para 114, another
In reserve, we will just see, consider that. You file your submissions. Your appeal is enough.
My lord.
Reserve. Oh, yes, yes, you have to say. Now tell us what is it, how many appeals are there? In batch?
So 11, 12 and
27.2, 27, 27.1. Oh,
27.1 may be dealing. 27.1, it's SSC's appeal, they have to.
It's our appeal, my lord.
It's your appeal, it's not just shows that, no? It's a different issue.
A different issue, my lord.
The technical, fee for technical.
Yours is not related to royalty.
The issue is, foreign entity was giving us managerial services to Indian entity. And for that, we have paid the payment. So it is not about software and all, my lord. That is
27.
Definition of fee for technical service.
Technical service.
Acha, okay.
We'll have it on next.
Let's say this, counsel for the appellant as well as the respondent in writ appeal number so and so states that the said appeal need to be deleted,
No, it's ITA, my lord, not writ appeal. ITA, income tax appeal.
ITA, yeah. Income tax appeal number
420.
need to be detagged with the other appeals with the other connected appeals. Instead, if that be so, comma, the appeal number so-and-so is detagged from the other appeals shown in the cause list. To stop, the same shall be listed on, just give a date.
Short date may be given.
We have heard, these were admitted appeals, which we have heard.
Yes, this is admitted appeal, my lord.
No, not yours. So shall we say with the consent of the parties? Huh?
Lord, formally it can be admitted today, my lord, and
Then we say with the consent, we have heard it. But does the common question arises in all the appeals?
please, same order.
So we can frame one set of substantial questions. That would suffice. Just say that admit the other appeals, no? Admit the, which appeal we should take it, the first one?
Please,
The following
criteria number
substantial
12.
questions of law arises for consideration in this batch of appeals. To stop with the consent of the counsel for the parties, comma, these appeals have been heard finally. To stop. The orders are reserved. Okay, we take on record the written submissions filed by the counsel appearing for the respondents in all the appeals. In all the appeals. Full stop. The same are taken on record. The registry shall scan and digitize the same and make it part of the record. Okay, that's all.
But
Reserved.
separate orders can be passed. May request for separate orders for each year.
Make separate orders. No, why separate orders? Okay, okay. Orders reserved, okay. See, then we will say, since the question of laws are identical.
My lord, because of the first matter, my lord, other matters get covered.
So we have
It's
to pass,
identical.
in each appeal, we have to pass order, arguments heard, judgment reserved. No, we are not tagging it.
Sometimes what happens is, my lord may pass it on the first month. The next 2, 3, my lord may say, similar question arose in that, following the reissue of that, we answer the question.
Together.
Normally that is what is done.
No, his case is they should be separate order. No, we will pass a common order, not separately. Common order was saying that common question arises. Only for his submission we are taking into this. Okay, thank you. Against this engineering?
No, there are various matters to there in that fact. There are the review petitions that come to.
But how are we concerned on that? Are we concerned? It's all right. But the only thing is that went in a review, also review dismissed. So it has attained finality. So today the judgment stands.
Other connected cases have been dismissed, not engineering analysis per se.
Out of those 200 cases, about 150 to 200 have been dismissed. Some of them are still pending, that is not in the process. So that may not take months for that. This part of the police actually bring it to another.
So you say the review is pending in some of the connected meetings.
On merit, there is a delay in merit, but also on merit, there is no.
Review in, what is the judgment name? Engineering.
that order which says on merits of the review.
Some are dismissed, some are pending. Thank you. These should be separate orders, huh? Once we will, then we. Questions of, you do one thing. All those separate questions of law, just repeat it. We take it that questions of law are identically framed. That's all.
My lord, serial number 27.1 may be posted for final hearing, my lord.
We have posted, we have given a date, ma'am, 27.1.
Much.
What is this 420 mean? What is this? For the dealing.
Thirty-two. Ishira Amarnath.
Yes, what do you say?
My lords, on merits of the appeal itself, my lords, which are going to the circular per se, my lords, if I may be permitted to submit on the merits of the appeal as such, my lords.
Then
Plus
why
the
are you
appeal-
relying upon this circular?
My lords, I'll invariably have to come to that also, my lords. I'll have to come to that also, my lords, if at all this court thinks that the order has to be upheld, then automatically the circular would be taken into consideration, my lords. Based on the circular, then,
Are relying upon this circular?
my lords, I relied upon the circulars in view of the fact that there's a manual processing that's been enabled of late, my lords, because the submission of the learned counsel
So
for the
what
response.
she says, the council says is only to the extent that what process need to be undertaken as per the directions of the single judge
Yes, my lord.
must be in terms of this circular.
Circular, my lords. In fact, the board or the department, in fact, never gave a proper quantification, my lords. That's the grounds, one of the grounds for the appeal, my lords. If the appeal memorandum is taken into consideration, my lords, the grounds for appeal is that there's no quantification, my lords. There was always a dispute with respect to the amount. There was no amounts agreed between the appellant and the respondents, my lords. In view of the same, circular of the board circular, para 10G, my lords, if I may be permitted to read, my lords. Page 204, my lords, the circular is.
Page
204, my lords.
Hmm.
My lords, I apologize. Lords.
Yes.
Relevant page 208, my lords. Relevant page. The circular starts at 204. Relevant page is 208. 10G, my lords, para 10G, which talks about further the following issues are clarified in the context of various provisions of Finance Act 2019 and the rules made thereunder, my lords. G, cases under an inquiry, investigation or audit where the duty demands have been quantified on or before 30th of June 2019 are eligible under the scheme, my lords. This is the issue with respect to eligibility, my lords. Section 2R defines quantified as a written communication of the amount of duty payable under the indirect tax enactment. It is clarified that such written communication will include letter intimating duty demand or duty liability admitted by the person during inquiry, investigation, or audit. This exercise was never performed, my lords, from the department's end. There is no quantification as per 2R. In fact, there is an audit report that's being communicated based on which they're relying upon, my lords. Audit report is at page 141, my lords. In fact, this particular audit report also has been challenged by the respondents. So there's no finality to this particular audit itself, my lords. There's no exercise of inquiry that's been concluded before 36/2019, my lords. In fact, if I may, my lords, page 141, my lords, the audit report starts, my lords. Audit inquiry.
But tell us one thing.
Yes, my lords.
You say that quantification need to be before 30th of June.
30th of June, 2019. my lords. Yes, ma'am.
And in this case, no quantification has been made.
No quantification has been made, my lords.
Huh? Why? Now let's understand from you, just one. Yes. Because your challenge is to that 30th of January 2020 communication in the writ petition. Rejection. Rejection on the ground, the quantification was not on or before 30th of June.
There is no quantification. Then the audit officer, my lords, is not entitled to make demand upon me and say that I have to remit that payment. Audit is not like a suggestion. They are saying this is due and payable. That is what I'm trying to point out at page 170. If I can just read the last 3 lines here.
What is the purpose of this scheme of SVL DRS?
It is a legacy dispute resolution scheme, my lords. All the pending matters, including voluntary disclosure. If I come forward without anything on record being demanded from them, if I come forward and say, I made a mistake while filing a return, now
I'll pay you.
I will pay you. That itself is acceptable under SVL DRS. Now, admittedly, I don't fall under voluntary disclosure. I fall under audit category. Now, my lords, under page 170, the last paragraph in the audit para.
Annexure P1.
Please, my lord.
Annexure P1.
Annexure P1. This may read, hence the SSE is liable for recovery of service tax amounting to 3 crore.
Which is that page?
170, my lords. 170, I believe it's 170.
Annexure.
My lords, there's no sure temporary.
Business is not correct.
My lords, the annexure P F3G. Yeah, my lords. F3, my lords. It's a continuation. Oh, sorry, subsequently.
My lords, it's jumbled a little.
It's
coming
annexure
from-
G.
Annexure G.
If I'm G2, continuation of G2. Well, it's continuation of G2, my lords. Annexure G2 continue.
What is the page number?
117, my compendium, my lords.
117.
170, my lords. There is 2 numbering, my lords. There's 117 also, but there's overwriting on that.
But are you sure it's 170?
My lords, if
In my writ petition page number, it is 117.
17.
Appeal page number is 170.
Read it, which paragraph you are reading?
Last paragraph, my lords. Hence, the SSE is liable for
Ah.
recovery of service tax amounting to rupees 3 crore 15 lakhs 10,072 in terms of the proviso to section 73(1) of the Finance Act, along with applicable interest, etc. SSE is also liable for payment of applicable penalty. The SSE is required to immediately pay service tax, interest and applicable penalties and produce the challan evidencing such payments. So this, my lords, is a quantification. They are not suggesting to me that something may be due. They are saying this is due, please pay. And the consequence of non-payment, my lords, is the rest of the steps will follow. SCN will be issued, etc. Now, what I want to point out is, my learned friend also made a suggestion that the department had not agreed to my quantification under the scheme. That's not correct because they had issued Form 2 to me. Form 1 is where I make my declaration. Form 2 is a definite communication from the department under the scheme saying, correct, this amount is correct, please come forward and pay. That, my lords, is under page 198 of the appeal. This is annexure M in my writ petition.
What is the date of this?
Date of this is 29/11/2019.
This is Form 2 under that scheme.
Under the scheme, this is the department issuing their quantification to me. Here, my lords, I only want to point out how this comes about. Form 2, the exact wording in Form 2 is, now therefore in exercise of the powers conferred under subsection 2 of section 127, the designated committee, after consideration of facts on record, hereby determines the following amount estimated to be payable by the declarant towards full and final settlement of his or her or their tax dues covered by this act and declaration under Sabka Vishwas Dispute Resolution Scheme 2018. Then my lords will notice the amount quantified even by the department is 36,21,817. This is the same amount that I have declared under Form 1. Now further, my lords will see notice for personal hearing. They say, if the declarant does not agree with the estimated amount payable as determined by the designated committee, he is requested to appear for a personal hearing before the designated committee on 4/12/2019 at so-and-so office to explain the reasons thereof. Please submit Form SVLDRS 2 capital A in case any other date and time of personal hearing is desired.
What is the date of this audit?
Date of this audit, my lords, is
1/12/2018, my lords.
29/11/20, huh?
1/12/18, 2018.
How do we get that?
That's audit.
The
That's
beginning pages of the
Beginning pages
audit,
have
my
a,
lords.
first page has a number, my lords.
No, when the scheme is 19, there is a question of 2018.
My lords, the cutoff date is 36/2019.
Huh,
Any amount quantified prior to cutoff date is eligible.
okay. How do we get the date here?
They have produced.
See at the bottom,
It's not at the bottom.
198.
One second. My lords, my audit inquiry is enclosed at Annexure C, page 141 of the appeal,
2718.
2718.
27/2018. So I am eligible. They also accepted my figure.
But tell us one thing, this order of 31/1/2020, read it.
My lords. Please refer to SVLDR's declaration.
Para 2, in this regard, to inform
Form that-
personal hearing scheduled on work for by issuance of form number this.
Yes, my lords.
However,
However, you have not appeared on the said date, hence the declaration is processed based on the records available. In this regard, the committee found that the issue was referred to DGGI, Bangalore Zonal Unit, by Audit Commissionerate. Thereafter, investigation was initiated by DGGI, but the amount of duty has not been quantified on or before 36/2019.
Who were to quantify?
DGGI, my lords. There was an audit that was recommended against this company, my lords, in view of so many misdeeds. In view of that fact, the matter got referred to DGGI.
But in any case, liability is 34 only.
My lords,
That's the reason you have asked for the personal hearing.
personal hearing subsequently.
Did not appear.
Yes, my lords.
My lords,
Subsequently, we go on to say that why it's been rejected also, my lords, in the said notice as per section 120. If I may be permitted to read the Finance Act amendment also, my lords,
125, any final, all persons
shall be eligible to make declaration under the category of investigation, inquiry and audit, wherein the amount of duty involved in the audit, inquiry, investigation has been quantified on or before 36/2019. Whereas in the instant case, the amount has not been quantified by DDGI, Bangalore Zonal Unit, on or before 36/2019.
What is the reason for not quantifying?
My lords,
The inquiry audit was made in somewhere in 18.
in 18, my lords, this is what has happened on the ground. One department has started inquiry process. Later on, another department, which is the intelligence wing, also has received information about the same company. That intelligence wing has taken its time to come up with their own show cause notice several years later, 2018 to 2020. My lords, now in between this, the government issues a scheme beneficial to the SSC, saying if you have a quantification, please come forward and pay. I am eligible as per the first quantification also. Now, my lords, it is unfortunate for the revenue that they have issued a subsequent show cause notice in the year 2020. But be that as it may, like I was suggesting this morning, converse cannot be true, my lords. If tomorrow in the show cause notice, they say that my liability is less than 36 lakhs, they will not extend that benefit to me under SVLDRS and say, now you pay lesser than this. Once quantified, it is quantified and it has to work. The logic has to work both ways. If today they have a higher quantification, I am entitled to the audit para and the demand under the audit para. Tomorrow, if there is a lesser quantification, also I should be going only by the audit para. I cannot claim benefit. I can't ask for a refund that I have paid excess. There is no provision. SVLDRS is also a self-contained code, my lords. There are judgments to that effect which we had produced before the learned single judge. That being so, my lords, it is not open to the department today to say they woke up to different set of facts tomorrow and there is a requantification. That's not how the scheme is contemplated to work in the interest of administrative convenience. This is ultimately a policy decision.
And when did you thought that there is a higher quantification?
My lords, as soon as DCGI informed about this misdeeds, my lords, it was immediately informed, and it was, I believe it was post issuance of the Form 2 itself, my lords.
Form 2 has come much before show cause notice. That is their acceptance of my declaration.
My lords, it's a matter of record. I can't dispute that at this juncture, my lords. It's a matter of record. But in view of so many other factors, my lords, this particular claim of theirs has been rejected, my lords, under the scheme.
My lords, if my learned friends.
Only on the ground that it's not quantified.
It's not quantified, my lords. On or before 36/2019, as per the Finance Act, as per the board circular, it's not been quantified. The amount is in dispute, one. And there's an investigation or inquiry that's not been concluded before that particular date, my lord.
But that's on a higher amount, you say it's not quantified.
My lords.
My lords, their emphasis seems to
Right.
be that it is not.
My lords, it's a
quantified.
higher amount. We have demanded a higher amount itself, my lords.
Where is the show cause notice for the higher amount?
My lords.
Annexure B. page
Annexure B, my
57.
lords. B and B1.
Page 57 onwards. My lords, their emphasis seems to be that a different authority has not quantified the amount. The emphasis is not under the scheme, my lords, respectfully, emphasis is not on who is quantifying the amount. It is the department. Ultimately, the SSC is not concerned which officer within the department has quantified it.
But what made you to issue this show cause for the higher amount?
My lords, based on the entire documentation that was received, my lords, from their end, there was an investigation. They, in fact, go on to record what documents have been received. They summoned certain company officials, opposite company officials also had provided services, to whom they had provided services. All the documents were taken into consideration. Post that, the show cause, detailed show cause notice has been issued, my lords. If show cause notice from page 57 is perused, my lords, it details the manner in which the entire records have been procured also, my lords.
Whereas this exercise could have been carried out even at the stage of the audit. For a lapse from their side, the SSC cannot be penalized. These people who supplied, according to my learned friend, my suppliers have been called for, again, without an opportunity to me to cross-examine them, which is an established practice. Without that, they have come up with one quantification. Could this not have been done at the stage of audit, I ask myself? Because, my lords, the same people I have supplied, as per the show cause notice, I have made my supplies in 2016-17. They were available to be questioned. My lords, in all of these contentions, they have not answered how my circular of 2019, which squarely covers the point, this dynamic nature of the proceedings, etc., that's not been answered. How that does not apply to me is the only thing that requires to be proven if the impugned order is considered.
My lords, the manner in which they have acted upon or approached this honorable court, by the bare perusal of the show cause notice, it would reflect the manner in which they've acted before all of this, my lords, before all these proceedings have been initiated against them.
My lords, may I suggest something?
Where is this 25/9/19?
25/9.
Is it here?
I believe it's not part of the record, my lords. Right.
25/9/2000.
2000, my lords?
19, 20.
Even 20. Oh, my lords, is referring to the circular.
Lords, that is at page
211. my lords.
nine.
25/9, 211.
Yes. But tell us one thing, once the cutoff date is there, and you may contest, but the quantification has not been done before 36/2019. Possible answer of yours is that Form 2 was issued.
My first reply to that, my lords, is quantification has been done because my audit para calls upon me to make payment pursuant to the quantification. In as early as 2018, they quantified my demand and said, please make payment. It is irrelevant whether I contest that demand, not contest that demand. It does not go away. Thereafter, my lords may kindly also see the scheme under SVLDRS.
Tell us one thing, is it your case that once done, they can't relook into it?
That's not my case at all, my lords. It's open for them to redo how many ever times. But if that redoing has not been done before the scheme closed, before the cutoff date, this 2020 scheme is long over, my lords. Scheme ended in 2019. Till that date, whatever they have done, they can take benefit of till the cutoff date. Now they sleep over what they have to do. They do this 1 year later. They also do it during COVID. All of these reasons we have cited in the writ. But my lords, my only point is under SVLDRS scheme, when the designated committee is handling my application, it is not that they are unaware of what is going on with the SSC. All the files that are relevant are passed on to them. They, my lords, under Rule 6, verification by designated committee and issue of estimate. It's a detailed provision which they follow. Then they give me Form 2. Then they ask for personal hearing. After having done this, they are going back on their quantification much later and saying that now a new quantification is available, one that I have not accepted in any case, and one that's come after the scheme has closed. This is taking benefit of what has happened
But
subsequently.
tell her one thing we have not understood. Once the learner single judge says it is not reasoned order, how are the principles of natural justice violated? You were given chance, you did not appear.
Malas, I will answer that. There is a precise document to that effect. Page 199. 199.
And the show cause notice is running in so many pages.
Please.
And how, you did not give any reply. What follows?
My lords, the
They have to only come to a conclusion. Look here, this is this.
My lords, I will answer that. At page 198, we saw Form 2. Form 2 at the bottom says you need to appear for a personal hearing only if you disagree with our quantification. Therefore, I issue Form 2A and say, yes, I agree with your quantification. I don't want a personal hearing. That can't be held against me because that's an option under the scheme.
We are right. We are only on that observation of the learner single judge.
Malas, that's an obiter. He says the
Obiter, that's the basis for setting aside.
his basis is our annexure R, my lord, circular, which circular covers my case.
See the reason. Para 5. So also he says,
Please.
1219,
Please.
issue regarding applicant maintainability.
My lords, let us forget for a moment the order of the learned single judge. This court, my lords, in an intra-court appeal, my lords know very well, is exercising 226 powers itself. Nothing different. My lords, today, if that learned single judge's order were not there, for an instance, my case is anyway covered by law, which they should be deemed to be in knowledge of. When the designated committee is rejecting my application, and there is a board circular which is binding on that committee, their own board has issued a circular saying, this is how you treat cases where there is a quantification before the cutoff date and after the cutoff date. Without anybody telling them, they should have taken cognizance of that circular and passed an order in my favor. When they don't do that, they cannot say because I did not attend personal hearing, they will take whatever view
Which
they
circular you are saying?
This is the circular at page 181 that I read out this morning.
2019.
This is the circular, my lords, which starts
180.
at annexure S. In the appeal, my lords, it is 214 page number. Dated 12th December 2019. Please see, my lords, over the leaf, para 5. For the purpose of eligibility under the scheme in some of the categories such as litigation, audit, inquiry, investigation, etc. Relevant date is 30/6/2019. However, it may so happen that the facts of a case may change subsequently. For instance, in a case under audit, investigation, inquiry, where the tax dues have been quantified on or before 30/6/2019, a show cause notice is issued after 30/6/2019. Similarly, a case where under appeal as on 30/6/19 may attain finality in view of the appeal period being over, etc. It is clarified that the eligibility with respect to a category in such cases shall be as it was on the relevant date, that is 30/6/2019. Board is also saying they understand this happens on a regular basis. They come up with a different quantification maybe after 36. That's of no consequence to the scheme. Because they are saying whatever is quantified by the department itself prior to 36/19 should prevail. because the scheme won't work otherwise, my lords. I will also cite one more example. There were a lot of cases which were pending appeal before this court, where we wanted to avail benefit of SVL DRS. We have to simply withdraw the appeal and say it is quantified prior. It is not that litigation or my rejection to that demand in a subsequent appeal bars me. Neither me nor them. My lords, in the interest of convenience, this date has been set. Now what they are trying to do is reopen the wheel, reinvent it and say that no, this date can't fly because some other authority had to come up with a different quantification. There is no emphasis in the entire scheme on which is the authority passing the order. It's of no relevance. It can be A, B, C within the department. The emphasis is on the period, on the dispute, on the category of service. It is not whether audit does it or DGGI does it. That is clear on a reading of the scheme itself. Had they in their rejection or in the even the appeal, my lords, had they said there is no quantification by the audit commissionerate, if that was their only reason, then I will bow down and say, yes, this may be a case of dispute. That is not their case. They are saying there is this also, there is something else also.
Who said something else?
Their contention is that DGGI, the Department of Director General of Investigation, they have come up with a subsequent quantification.
So the show cause notice was, everything was by a different department.
A different department. The directorate and the intelligence wing is different, my lords. The audit is different. Both can.
The audit wing.
Audit wing. Audit wing is my own word.
Which they gave that form to.
No, form 2 is by a third entity, which is a designated committee under the scheme, which comprises of different officials sitting together. There are 2 people in the committee. Every committee has 2 members.
So one is one issues quantifies it at 34. The other separately starts for a higher amount.
This 34 also, my lords will appreciate, is a much reduced amount because of the scheme benefit. It is a much higher amount even according to the audit paras. But I am eligible to take deductions under the scheme, which I have. They agreed, they issued form 2.
Then they come down to 34.
Please, it is not as though there is such a vast difference between the amount payable under A and B. I understand my lord's hesitation in allowing us to pay under the SVLDRS scheme because admittedly the SCN amount looks much higher, but that is not the case. It is not a vast difference at all. Because if my lords look at the audit paras and the quantification under those paras, it is close to the SCN demand itself. But I am enjoying benefits under the scheme for deductions. No interest, no penalty, only 50% of the demand needs to be paid. That is the government giving me relaxation.
How many cases would be there of this nature?
Many, my lords. In fact, we had filed 5, 6 such cases, none of which have been appealed, only this one's been appealed. Like that, there were many batches at the time that this scheme came.
But why they were not appealed?
My lords, in those cases, there were different reasons were there. First of all, it was not a case of these different quantifications. In those cases, sometimes portal did not work. My challan was generated, I could not pay before the last date. So there were certain relaxations given. Those kind of.
It's not similar fact circumstance at all, my lords. It's with respect to certain screenshots or declarations not being accepted.
But tell us one thing, which is the nodal department which would consider the benefits under the scheme?
My lords, that's the committee, my lords. That is the committee in this, my lords. GST. SLVDR committee, my lords.
So committee was not involved in the higher amount quantification?
No, my lords. It's issued by DGGI.
So if that being so, why not 34 must be put as the figure?
My lords, there are.
See, what is the sort to be taken is the benefit under the scheme.
Yes, my lords, I understand.
Third, somebody okay, look here, no, you are not. How are you concerned with that scheme? Or you will communicate to the scheme in charge or the committee.
Yes.
Look here, this is what we have come to know, not in all. You can't quantify it at 34.
My lords, that was done at a later stage. That was the only issue, my lords. The quantification was done at a later stage, which was communicated to them by way of a show cause notice. But the form 2 was issued much prior to all.
We want to know how many are there cases of this nature?
That he will be in a better position.
I know, you're right. How many are there?
My lords, different commissionerates have different numbers. We'll have to inquire with various commissionerates. At
the problem is right doesn't know what is happening in the left. That's the point.
My lords, the fact of the matter is because we were not able to make payment under this. We filed a contempt petition. Now that contempt petition, unfortunately, in my lords know, in all contempt, I have to write the name of the officer. I cannot simply say designated committee as the respondent. My lords, it has become impossible for us to find out who is the officer in the designated committee because it's a completely online process. I am, my lords, at loss. I'm trying to explain to the registry that, look here, it's a faceless scheme. I don't know who's the other person, and for good reason, because I cannot influence the outcome.
You have the chairman of the board. Chairman of the board is there, make him.
My lords, that.
My lords, and then when we made manual inquiries on ground, it so happens that there is no committee. That's why I made that submission on the last date. I don't want to simply name someone.
Yeah, right, yeah. Then you will name a person who has to implement the order.
Yes.
See, we want to know how many are there of this nature.
My lords, I'll try to ascertain from various commissionerates, my lords, with respect to this.
What's happening is the scheme is there, the scheme need to be implemented by X department. The Y department comes with another figure. This scheme is defeated.
The purpose of the scheme is taken away.
Is defeated.
Yes, my lords. I'll try to ascertain the exact number.
What happened in this?
That's clearly. My lords, there are various appeals on various other grounds. This might be one of the grounds where there is
And
quantification.
who under the scheme is competent to come out with the audit report?
That's-
This
Yes.
scheme which need to be implemented. They are the competent and they
The-
have done that form to every.
Form two, my lords, yes, the committee itself, designated committee itself, my lords, forms.
You're not giving effect to.
That's bill.
Because as of today,
See,
I
this
have
is what troubles.
2 years in litigation, my lords. As of today, I have spent after getting a favorable order.
And then now the quantification has been done by the investigation.
My lords, that's.
How
based-
much?
that-
How much is the quantification?
1,71,00,000.
No, my lords, there's
So
various
that's much
numbers, my
more
lords.
than
Total
34.
number is around 3.15, my lords, if I'm not wrong.
That's much more than.
Way more than what the amount has been ascertained by.
Because that's what I'm trying to explain. Audit may, if we calculate the total of audit paras, it is not so much different. If my learned friend, on the contrary, if let us say show cause notice is my quantification date, and I apply the benefits of the scheme to this 3 crore 15, etc., I will come to the same amounts near that figure.
But did you challenge this figure?
Which figure, my lords?
This 3 crore odd
No, my lords.
Show cause notice we have not challenged because I am under the
in the
impression.
writ petition?
No, because I am writ petition, my lords, I was under the impression that my SVLDRS application will be allowed, discharge certificate will be.
That becomes a more academic.
Please, it becomes honest after I get my discharge.
You are more concerned on discharge.
I have to obtain my discharge, which is the closure of this dispute,
Even including this amount,
including any amount further,
a
any,
higher amount.
all quantifications pursuant.
Were
to
you
the
not
scheme.
required to challenge then this higher amount?
My lords, no, my case is simply this. I am not saying show cause is correct or incorrect. I am only saying rejection under SVLDRS is incorrect. Now, consequentially, suppose my lords were to take a view that the learned single judge had heard my SVLDRS ought to be rejected, automatically consequence will follow that my remedies under the Finance Act will stand revived. I can challenge the show cause notice. It's not like I need to make payment under the show cause notice tomorrow. I will be able to file a reply. I will be able to contest an appeal. Even in the appeal, my lords, free deposit comes at a much, much later stage, not at this stage. It is not that I have conceded to the amount here, but I want the benefit today. My lords, therefore, the
See, we are only thinking that without challenging that higher amount, you are seeking the benefit of the scheme. And they are relying upon that higher amount.
that higher amount came after the scheme closed.
Right? Scheme closed. But your claim is also for the benefit of the scheme which was closed.
Hello?
Your petition is also seeking benefit of the scheme which was closed.
I am
So
saying,
no, yes.
well, as I am saying this way, if the scheme were to be implemented properly, my case would not have been rejected. Therefore, it's not my fault that I'm in court after the scheme has closed.
That's right, that's your explanation now. But so closing of the scheme is immaterial.
To an
Consequential.
extent, yes, my lord. I am
Oh.
only saying how did they rely on extraneous material? Now I produced A, B, C.
That's the challenge. That's what you are saying. Extraneous material for the purpose of higher quantification.
If my lord's question is, did I challenge it under my prayer in the writ? I did. I said, set aside the show cause notice. If that is the question, and if I've understood.
Yeah, that's the
correctly.
question.
Then, my lords, I have. At page 53, if my lords were kind enough to see the prayers in the writ, I have. I have said it is barred under the scheme. Therefore, I am asking for setting aside that higher quantification. And then I have said, give me benefit under the exact circular which the learned single judge has relied upon and given me benefit.
But tell us one thing. No, and that has not been set aside.
Which one, my lords?
The show cause of 3420.
He didn't deem it necessary. To be very fair, my lords, if the show cause notice, I mean, it's not necessary to say, simply because the SVLDRS application has been accepted by the learned single judge.
So dehouse that, the benefit under the scheme be given. That's the in sum total.
And in consequence, this will go away.
We don't know.
My lords, discharge certificate is final. I can read from the
That,
scheme.
okay, that takes care of any liability.
Please, the scheme
Every
says
liability.
everything washes away if discharge certificate in Form 4 is issued. Scheme is saying that.
Then that must proceed by the quashing of 34.
My lords,
That must precede the quashing of 34 or 20, the show cause.
please.
Otherwise, the show cause in a way, existence, according to you, has no effect.
Has no effect. So learned single judge says, as soon as I make the payment, within 15 days, please issue discharge certificate in Form 4.
You are out, so 34 would not be implemented against you.
Please.
See, we want to know what is the purport of the act or the scheme. Can you now come during the, once you have undertaken every exercise, you will say, no scheme is going to be implemented like this. No scheme would be, this is only to attract, no scheme would be implemented then. On one hand, you bring a scheme, on the second hand, you say this is the amount.
Let's various others assessees calculations have been quantified, accepted, they've been issued Form 4 also, my lords, to that effect. This is one-off case where this has been disputed also. This one-off case cannot be taken as a landmark case for all other.
We want, you should take instructions. How many cases are of this nature?
Yes, my lords. I'll ascertain that time.
It will have a bearing across.
Yes, my lords. Thanks.
Right?
Yes, my lords.
You're getting. Tell us one thing. Based on this judgment or the order of the learned single judge, are there any other petitions filed seeking a similar benefit where the earlier quantification done, a subsequent higher quantification has come? People are seeking the benefit as you have sought, give the benefit of the scheme. And the people have succeeded on the strength of this order.
On this order, or can I even find on that circular I'm relying?
No, you have, I hope we are clear.
On the basis of this order.
On the basis of the impugned order, did the others have come, sought the benefit, similar benefit which have been granted, which has been granted?
I will have to look into this. He will also know.
There are a couple of cases, but there's not per se with respect to quantification or this issue in hand, my lords.
We are more concerned on the higher quantification.
With respect to the scheme, there are numerous, my lords.
No, not scheme numerous. Scheme is huge.
Oh, I'll have to ascertain that. My lords.
What we are saying is just you must understand this.
Yes.
Quantification done.
Yes.
Not challenged. Show cause notice not challenged, no personal hearing taken.
Yes.
You give Form 2. This is an action in furtherance of that circular scheme.
Yes.
But some entity within the system comes out with a higher quantification.
Yes.
And you said that quantification, no doubt, are not under the scheme. Totally extraneous to the scheme.
Yes.
Says there is a higher quantification. Whether that quantification can be an impediment to the respondent to seek the benefit of the scheme.
Well, I'll ascertain that.
And whether
yes,
any cases of this nature where quantification done, a higher quantification by a third entity or a third authority
Yes.
contrary or not contemplated under the scheme have also come forward.
Yes.
Let us know.
Yes.
We have heard the learned counsel for the parties at length. Will stop to come up for further arguments on list on. You will just take
Yes,
look
ma'am.
into that, take it, ma'am, you also.
Please.
And then otherwise we want to know what is the intent of the scheme. The scheme may be beneficial. Now you say, can you defeat the whole scheme by saying that now there is a higher quantification?
Because there are umpteen judgments on the point. If there is two manners in which any provision of the scheme can be interpreted and both are equally viable, then the benefit has to go to the assessor. It is like any other case in tax, my lords, where there is an
Right,
exemption.
that's true. Ultimately, the benefit which inures to the benefit. But here the issue is on a quantification.
Please.
Now,
Yes.
what we are putting it to you is, and you should
Yes,
also, the quantification need to be undertaken by the authority which is contemplated under the scheme.
Yes.
Not a third or a fourth entity.
Yes.
Getting the point?
So may I make one small submission there? Quantification under the scheme can come from any authority,
It's any authority.
not by the designated committee. I appreciate the difference here. The prior quantification before 36/2019 scheme was not there at that point. At that point, any authority could have quantified. And I could bring that before the designated committee and say, I want to rely on this. Thereafter, my lords are right that the designated committee takes charge and they come up with their quantification, issue that in the form of Form 2. Extraneous quantification in this case has come once the scheme has closed and DGGI has conducted their own investigation.
Oh.
There, my
So you
lords,
say anything need to come, a higher quantification by a third entity need to be before 30th of June.
precisely.
That's what,
That's all it is.
oh, get the information, we'll
Yes.
hear. And give the date, man, just give it next week.
28/10.
Okay. Shall we go, man? Use any other matter? Just call.
So grateful.
Achha.
My lords,
Yes,
I appear for respondent number 1, my lords.
who is the appellant?
Appellant is absent, my lords. Lords, it may be listed day after tomorrow, my lords.
List day after tomorrow. None for the appellant, list day after tomorrow.
Grateful, my lords.
23. 10. Serial number 12. Serial number
This
12.
is your matter?
But the notice is not issued. And there appears to be some non-compliance. I have not been served either. So unfortunately, I can't even assist your lordships.
Serial number 12.
My lords,
Serial number 12.
my lords.
What is the issue
I have not been served, my lords.
for non-compliance? Is anyone appearing? Did they appear in the after morning?
It's been passed over twice, my lords.
There is no appearance for the appellant even on the third call. Good stuff. We find that the objections as notified by the registry objection as notified by the registry has not been cleared. The appeal is dismissed for non-prosecution and in default.
My lords.
That's it, ma'am.
Thank you.
ಲಿಂಕ್ ಹಾಕ್ಬಿಡಿ ಸರ್ ಹೋಗುತ್ತೆ ಈಗ
Yes, ma'am.
For pronouncement, serial number 1, Shri Somshekhar, Shri Nagendra Nayak.
I appear for the appellant, my lord.
Appearing for the respondent, my lords.
See, we have allowed the appeal.
Yes, my lords.
The pass by the learner is liable to be set aside, we order accordingly. The appeal is allowed.
Much obliged.
Serial number 2, Shri Anirudh.
The appellant.
Respondent number 3, my lord.
We accordingly hold that the impugned order of the learner single judge need no interference, the appeal being without merit dismissed.
Deeply
Publish.
obliged.
Give it to me, I'll sign it. Individual pages.
Yes.